Okay. I call to order the regular meeting of the Oradell Zoning Board of Adjustment for October 21st, 2024. It is 7:30 p.m. Notice for this meeting was published in the official newspaper, promptly posted in Borough Hall, and filed with the clerk's office in accordance with the requirements of the Open Public Meetings Act. This meeting is a quasi-judicial proceeding. A decorum appropriate to a judicial hearing must always be maintained. Any questions and comments must be limited to issues that are relevant to what the board may legally consider in reaching a decision. We'll do a roll call. Mr. Barrows?
Here.
Mr. Bartlett is not here. Mr. Devine?
Here.
Here. Ms. Zadinsky?
Here.
Mr. Camporielli? Not here. Ms. Day? Not here. Mr. Santaniello?
Here.
Ms. Cobb?
Here.
And Mr. Michaelman here. Pledge of allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Right. Next, approval of the zoning board meeting minutes for September 16th, 2024. Does anybody have any adjustments, amendments, exceptions to the minutes as submitted to you? In that case, may I have a motion to adopt the minutes as submitted?
Also move.
Okay, do we have a second?
Second.
We have a motion and a second. All in favor? Aye. Any opposed? No. The minutes adopted. Correspondence is listed in the agenda and is on file in Steve's office if anybody wishes to review the correspondence. All right. What do we have there? The zoning board procedures is necessary. Probably necessary. I see a lot of fresh faces here. Some of you, this may be your first time attending a zoning board meeting. What happens in the circumstances, when someone wants to do something to their property, they'll need a permit. They go to Steve's office, they submit the plans. If the code permits it, they're given their permit. If there's a problem with what they want to do in the code, under certain circumstances, they may ask for a variance. Under those circumstances, they come before the board and they put forward their case as to why they believe they're entitled to a variance. Burden of proof is on the applicant. It's not on us to justify the code. It's up to the applicant to show why they should be given a variance. If they meet that burden, we'll vote, and if they get a majority, they get the variance. If not, it can go to court. Even if we approve it, it can still go to court, but that would mean generally members of the public have to file for that. So, hopefully, that explains what we're doing here and why we're here. If we can swear in the professionals?
We will. The three professionals have previously been sworn in connection with United Way. We'll swear them in connection with 680 Kinderkamak and 420 Kinderkamak. Will you all raise your right hand, please? Do you swear or affirm that the testimony you will give in this proceeding shall be true, self be done?
I do.
Let the record reflect that construction official Depket, Borough Engineer Atkinson, and Borough Planner Ryder have all been sworn.
Thank you. All right. Well, obviously, we're not going to start any new cases after 10:30. We have 3 cases on the agenda. What I'm going to do is give each case 1 hour. So you can see who's first, who's second, who's third. We'll have a 10-minute break at about 9:30. Well, I'll look for a normal breaking period at that point or ask the attorney. Either way. So that's where we are on that. Now, we have some administrative business to take care of, so I'm sorry that this may bore you, but it's something that has to be done based on prior cases. Karen, calendar 878-24 was previously adopted, and you have the resolution in front of you. May I have a motion to adopt the resolution?
Yep, also move.
Okay. Do I have a second?
Second.
Chris. Let's see who is eligible to vote. Okay. Burrows and Morday. Okay. For Marvin, yes. Emily?
Yes.
Tom?
Yes.
Okay. Chris?
Yes.
Jeanette?
Yes.
Kevin is not here, absent. Carlo is absent. Okay, let me... My handwriting's getting worse all the time. Your handwriting does deteriorate with age, okay, I can tell you that. Next is Santaniello. You're not going to vote on this.
Figured.
It's his case. He can't vote on it. Does any member of the board have any amendments, adjustments, et cetera, to the Santaniello resolution? No? Okay. Let's see who is eligible. Barrows, Chris, not qualified to vote. Barrows, okay, once again, may I have a motion to approve the resolution?
Also move.
Emily, Bob, and no, you can't second it.
I will second it.
Okay. What do we have here? Thomas Devine. Marvin, yes. Emily?
Yes.
Okay. Tom? Yes. Yes. Okay. Jeanette?
Yes.
Kevin is absent. Okay. Yep, getting worse all the time.
Can I sign it?
Oh, no, you can't sign it. You sign-
Probably not a good idea.
Thank you. I'm glad you... That was a good catch. Yes, thank you. Okay, next is Carrie and Robert Thorne, calendar 880-24. Once again, anyone have anything about it? No? Can I have a motion to approve?
Also move.
Can I have a second?
Sure.
Chris? Earn your keep. Okay. Once again, Burrows and Day. Marvin, yes. Emily?
Yes.
Warren?
Was I?
Oh, no, you're not qualified. Tom?
Yes.
Chris?
Yes.
Jeanette?
Yes.
Kevin is absent. Campariella is absent. And Maureen is not qualified. Okay, that's the next one. And the final one is Geraldine and Peter Loria, calendar 881-24. Anyone have any changes to that? No? I can have a motion to approve?
Also move.
Emily, Cobb, second?
Yes.
Okay. All right. And once again, Warren and Maureen is not qualified. All right. 4, Marvin, Emily,
Yes.
Tom,
Yes.
Chris,
Yes.
Jeanette,
Yes.
Kevin is absent. Carlo is absent. Maureen is not qualified. Okay. I want to thank you all for indulging us on this. But you see, this is really what happens when we finish and the vote doesn't really do anything other than say we can reduce this to a resolution, and that's the legal document. So if we don't have a resolution, the case isn't complete. So thank you all for indulging us. Now we'll call calendar 874-24, BCUW Madeline Housing Partners, LLC. And again, it's 7:39. Yes, thank you. We do have 2 people stepping down. It's 7:39. We will try and wrap this up at 8:39.
Thank you, Mr. Chairman.
Mr. Whitaker, I just mentioned, you note that there's only 4 members on the dais.
Yes, we will not bring,
You're not going to want to vote this.
Not be a problem because we're not going to conclude by 8:39.
yes.
Harry, you're fast, but maybe not that fast.
I don't know whose this is, but we're going to need this space here tonight. Get this out of here. Thank you. Good evening. For the record, Bruce Whitaker from the firm of McDonald Whitaker, representing the applicant, Bergen County United Way, Madeline Housing. Just a very quick overview. They've had a series of hearings here in connection with this project. You've heard all of the testimony from Tom Toronto, who explained to you what was proposed for this site, went through the whole use aspect of the site itself. From there, we've had the testimony of Mr. Halls in connection with all of the engineering aspects. We had him back again to testify as to modifications to the plan, which was based upon reports that were received by us from your engineer. We've had the benefit of your planner's reports, and we're ready to proceed tonight with the planning aspect. I also put on the record that we had complete testimony as it pertains to the architectural aspect of the building and the site itself from a landscaping perspective. So we.
The microphone, he's having a little trouble. If you could, there's a handheld mic in front of you if you want to continue to stand, yes.
Usually I'm too loud. In any event, with that said, a recap, we've gone through the managerial and use aspects of this. We've gone through the architectural aspects. We've concluded with engineering. So tonight what we'd like to do is present Mr. Halls, who's still under oath. He was qualified in both being the engineer of record and also the planner of record. And tonight I want to direct his attention to reviewing the planning aspects of this and the variances being requested. Have Mr. Halls.
Do you need more room at the table?
What's that?
You need more room at the table?
No.
This out of here.
No.
Just lay it back. Mr. Halls, you are still under oath, and Mr. Halls, when he was first voir dired, I voir dired him on both engineering and
I
planning.
think he was qualified.
Qualified for both.
That was the main meeting, I believe.
Yes. Mr. Halls, you are going to review with me this evening the planning aspects of this application. Is that correct?
Yes.
And you've testified to the fact that you've been at the site, that you've created the plans that were submitted with this application, and you've had the benefit of the review of both the engineering reports and the planner's report of May the 17th, 2024. Is that correct?
Yes, that's correct.
All right. So with that said, I'd like you to walk us through your analysis as a planner as it pertains to the variance request that we are seeking in connection with this application.
Well, in preparation of my planning testimony, I did visit the site again, just to refresh my memory. I know that I mentioned before that I've been to the site. I also reviewed the borough's master plan and the 2022 amendment to the housing element and fair share plan of the master plan dated 4/11/2022. We are here for Bergen County United Way, Madeline Housing Partners, which are seeking site plan approval to construct a 2-story supportive housing group home consisting of a 4-bedroom home on the first floor and 2 units on the second floor, a 1-bedroom and a 2-bedroom unit. All of the entire housing unit is a part of the group home. Because of the community center and utilizing the community room in the first floor of the unit. And that is a group home which is permitted in all residential zones in New Jersey based on MLUL. Specifically, a group home is permitted in all residential uses. And also the group home is an inherently beneficial use, which means it's a use which is universally considered of value to the community because its fundamental serves the public good and promotes the general welfare. Specifically, you look in the municipal land use law, group homes are listed as an inherently beneficial use, and also specifically, group homes are listed as being allowed in all residential zones. That is our proposal in terms of the site plan. Along with the site plan, we do have 3 variances that we're seeking. We are here before the zoning boards because specifically we are seeking an FAR variance. The FAR is a D4 use variance, and we do need the board's approval for that. We also have 2 C variances that we're seeking. One is for combined side yard setback, and the second is for lot coverage, or for the public, it's basically the improvement coverage of the property itself. Specifically, you heard testimony from the architect, specifically on the house, on the proposed group home and the size of the group home, that the state, in terms of the number of bedrooms associated with the group home, is 4 bedrooms that they're looking for, they can get their financing for, and the licensing agreement with the state. You also heard that from Tom Toronto in his testimony. Then there was also specific questions from the public about the size of the group home, and James Vergona had gone through, the architect had gone through and analyzed the size of the unit itself, and determined that basically the size of the group home that's proposed is the smallest size group home that can be placed with the property and be functioning in accordance with the current expanded ADA requirements involved with the group home, and also for access to and from the home itself. So that we have on the property itself, we do have the group home along with the 2 units on the second floor. Specifically, the property, as I mentioned before, and through my initial testimony, was an extremely very irregular shaped piece of property. While it has a wide frontage, its depth to it in comparison to its width, it's a shallow depth lot in comparison to its width. It was a piece of property that the municipality acquired on multiple occasions and added additional pieces to. And we now have a lot that's irregularly shaped. If you're looking at it, it appears to be somewhat regular along the street frontage, but then on the right-hand side, the side property line comes into the property on a steep angle coming into the site itself. Also on the property, as there was testimony, we have easements on the right-hand side of the property. There's a sanitary sewer easement, a storm drainage easement, and a water main easement, and they are all located on the right-hand side of the property itself. The surrounding properties are all residential properties. This is all located within the I can't think of the name of the zone. Why am I having a problem here?
R4.
R4. Thank you. R4 zone district. And the proposal is, in terms of the proposed group home itself, the 2-story group home, the architect has designed in a fashion so that we're not exceeding or coming close to the height requirements. It's actually substantially lower in height than the permitted height in the zone. The proposed house is only 27 feet high, where 34 feet is permitted. So the house is actually 7 feet lower in height than what is permitted. So that the architect has done several things in an attempt to scale the mass of the home itself and reduce the height. In terms of the variances that we're seeking, if I talk first about the C variances, the first is the combined side yard setback. The zone requires, it's a mathematical formula to come up to the combined side yard, but in this case, we need a combined side yard of 109 feet. That's viewed from the street. So both the combined side yard, both the setback from the left and the right. If we look at the proposal, if we're standing on the street looking at it, and we measure at the front setback line of the house itself, we actually meet the combined side yard setback. We have 110 feet measured at the, along the front setback line. If you took the furthest projection of the house on the left-hand side and the projection on the right-hand side, and you look at those two distances, they add up to 110 feet. So we actually have designed the house in a fashion that meets the requirements of the zone, and so that you've got the appearance of a combined side yard setback, which would meet the intent of the zone. However, because the property, our side property line, is skewing in at an angle, the left rear corner, or the right rear corner of the house, is closer to the side property line on an angle perpendicular to that property line. But if you're standing on the street, you will still visually have the effect that you have the combined side yard that the zoning ordinance is looking for. And basically what a combined side yard is for is for making sure that there's not a massing of the houses next to each other and there's adequate open space between the properties. And in this case, because of the position of the home and how we've designed it with the home itself, I believe we've met the intent of what the ordinance is, and we actually meet the dimensional requirements along the frontage itself. However, again, because of the skew of the angle as our side property line is going in, we have a reduced side yard from the combined side yard setback. Also, we are not adjoining, if you look at our lot itself, our lot is not two sides next to each other. Our side is adjoining the rear of the homes that are on Garden Court. So that right property line is not a side-to-side property line, that is a side-to-rear property line. And also with that, there's a substantial open area or a separation between the houses of our proposed house and the houses on the adjoining lots. And again, we meet all the zoning requirements in terms of setbacks and separations between the homes for that. So in my opinion, based on the fact of how the site was designed, what we're providing, that the board can grant that variance and of the combined side yard setback variance.
You testified that the lot is irregular in shape. Just place on the record, this is not your typical rectangular lot or squared lot with perpendicular lot lines, correct?
No, it is not. In fact, I believe this is a combined section of 3 or 4 properties the borough has acquired over time. That gives it the odd shape. On the left-hand side, there was a lot that was acquired at that point in time. It's actually the lot line, the lot was more triangular in shape, but the original portion of the lot was triangular in shape. But then the borough acquired the rear of 2 properties on Garden Court to expand the lot to the back, and that gave it more of a rectangular shape, or I guess, or trapezoidal shape than what you would normally than what it was in originally.
But correct me if I'm wrong. If I look at that exhibit that's up on the screen right now, we have some 9 lot lines surrounding this property, correct?
That's correct, yes.
Thank you. Okay, moving on to the other C1 request that we are making.
Yeah, the other one is the C1. There was testimony specifically about why we're providing the number of parking spaces that we have. Specifically, we're looking for a lot coverage variance. With the lot coverage variance, we're required to provide a maximum of 40% lot coverage on the property itself, and we are providing 45. Gosh, I can't find my number again. We are providing 42.4%. So we exceed the coverage by 2.4%. Specifically, the home itself, the proposed house is at 20%, where 25 is required. So we is not actually the size of the home that's generating the impervious coverage. It's the parking itself on the site. And we had discussed that the roadway itself is it's a 40-foot right-of-way across the frontage of the property, and the actual pavement width is only about 24 feet wide, 25 feet wide. And we are located where Brookside Avenue comes into Genther. It is a corner where we felt that if we had overflow parking, it would make it more difficult if we park cars in front of our lot when we had overflow parking. So we thought it was a better plan and a better alternative to provide that on-site parking itself. We are over-parked on the site. The RSIS requires only 7 spaces, and we're proposing 8. And you had heard testimony from Tom Toronto that while we don't need that many parking spaces on a daily basis, we thought it was more beneficial to add that additional parking spaces for the site itself. So in the event that we do have visitors coming to the site, or in that chance where you have additional people that are on the site, that there's on-site parking. We did not park along the street where it might cause a disruption of the turning movements from Brookside on to Genther Avenue. Now, I do have an exhibit that I'd like to present to you. We could provide the same parking spaces and meet the 40% requirement, but we believe, again, that what we're proposing is a better parking alternative than what would be required based on the 40%.
Thank you.
Mr. Whitaker, what exhibit number are we going to give this?
So you would ask that
I
question.
think we're up to 14, maybe?
This would be 14?
I think.
Yes.
And
Mark at 8/14 with today's date, 10/20.
do you have a PDF that will go up on the screen?
I do not. I didn't think of that.
Okay.
Sorry.
No.
So please explain what this alternate plan shows.
Yes, so the parking that we had proposed, we had separated the parking from Genther Avenue. We have a 19-foot setback from the right-of-way towards the parking on Genther Avenue. That's on the site plan that was submitted to the board, and the board has reviewed before. And the reason we selected that was there's a massing of trees on the right-hand side within the easement. Actually, you can see it on the exhibit that's on the
screen.
Screen, thank you. It's the third thing that goes. Yeah. That shows the trees that are located. I believe there's 4 trees on the right-hand side. If we pull the parking lot closer to the street to be 10 feet from the street line, from the right-of-way line, and then what we do is we would add the 2 parking spaces that are in the left rear. We would bring those to the front also, and we can fit the full parking area on the site, fully conforming, and yet it would, and we would reduce the coverage down to 40%. So we would still have the same parking we discussed before, still providing 8 parking spaces, and we would not need the variance itself. Why didn't we do this initially is because we thought that preserving those 4 trees that were there was more important, or was a better planning alternative than by removing the trees and bringing the parking lot closer to the street. We thought that would be more in keeping with the neighborhood, with having a streetscape with vegetation rather than bringing the parking lot closer. We could do that. We could add landscaping in along the parking lot. But in this case, we thought keeping the trees was a better alternative.
So just to reiterate, the applicant would accept either proposal that you've testified to.
That is correct.
And the overage that we have as it pertains to improved lot coverage is generated purely by the parking lot that's proposed, not by the building itself.
That is correct.
And on the basis of the parking lot proposed in both examples, you have a parking lot that has more than the required parking spaces for the use.
That's correct.
And the proposal to add this additional parking space is merely to avoid, at least in one possibility, a parking spot on Genther, but rather have it on site itself for overflow.
Yes, we meet, as I mentioned before in the testimony, we're only required to have 7 parking spaces, and we chose to provide 8. This is not a use that generates a lot of traffic. However, there are occasions when we do have visitors to the site that we thought the additional parking would be beneficial.
Thank you. Let's move on then from the next request.
All right, and the one that we're here for is the FAR. In terms of the floor area ratio, as I specifically with that, this is a use variance that's basically evaluated in the case of Coventry Square versus the Borough of Westwood Board of Adjustment. Because the proposed use is a permitted use, it is not a prohibited use in terms of the use itself. So in terms of the FAR, specifically, the applicant has to demonstrate that they have the special reasons for granting of the use variance, which must show that the site will accommodate the problems associated with the FAR larger than what is permitted by the ordinance. And specifically in this case, we are maximum permitted FAR for the size property we have is 3,938 square feet, and we are proposing 5,930 square feet, or it's larger by 1,992 square feet, which is approximately 50% larger than what is permitted. And if we look at what exactly, by adding that additional square footage or to the floor area, our existing property that we have is 19,943 square feet. It's 2.6 times larger than what is permitted for the lot size in the zone. The proposed building coverage for the lot is 20.2%, where a maximum of 25% is permitted. The proposed building we have is 80% of what is permitted, or we are 20% smaller than what is permitted. So we're showing that our proposed house is not at the maximum at all on the property. We have a smaller home than what is actually permitted in terms of coverage. In terms of the front yard setback, we are conforming, rear yard setback we're conforming, and side yard setback we're conforming. We also talked earlier about the combined side yard setback, and in appearance along Genther Avenue, we're also conforming with that section also. In terms of the building height, our proposed building height is 27 feet, where 34 feet is permitted. It's 7 feet lower, or 20% lower than what is permitted in the zone. So architecturally, the architect has been sensitive to the size of the home itself and reduced the size of the home in an attempt to reduce the mass or appearance of the structure itself. The proposal, I believe, provides adequate light, air, and open space, which is in accordance with the zone district requirements. Obviously, if we meet all the setbacks, we've provided for that additional light, air, and open space with the property. Now, if we take it one step further and we look at what is the size of the property, it's 19,943 square feet, 2.5 times what is required in the zone. If we look at, could we subdivide the property? If we looked at the property as being one lot being 7,500 square feet and a second lot being the remainder, or a remainder size lot, the first lot would be permitted to have a 35% FAR, and the second lot would be able to have also the figuring. It's the way you figure out the FAR. It's sizing and then adding on. So if I just look at it, what is permitted, if you took the 2 lots, the FAR permitted within the 2 lots, if we went through the equations, would be allowed to have a 6,115 square feet on the property if we subdivide into 2 properties.
And that would be more square feet than what is being proposed.
We are proposing 5,930 square feet, and so we are providing less than the property was subdivided. So in essence, if we divided the property, you'd be able to have the same square footage, or FAR. What we have is we have it in one structure, and the reason we have it in one structure, as you heard from the architect, specifically, This group home has to be a specific size to fit on the property for the group home, 4-bedroom group home. And then if it's also to be a group home, we're taking the additional units on the second floor. They are utilizing the same community room in the building. They cannot be separated. We cannot have one smaller group home. The 2 units would not classify with the state as a group home as 2 units. You need to have 4. So the building itself has to be enlarged to what we're proposing with this proposal.
So let's just work through a couple of things there. Am I correct in saying that if we created 2 lots rather than the one that we have, we could actually wind up having more square footage than we would actually need, but we would be conforming to the code and would not need an FAR variance?
That is correct.
And in connection with proposing 1 building versus 2, am I correct in saying that the 1 building is what was contemplated in the agreement between the Borough of Oradell and the applicant when they decided to put this group home as proposed on this property?
It is, yes.
And that's contained both in the agreement between the borough and the applicant, as well as in the amendment to the housing element and fair share plan, all of which have been submitted in our list of exhibits.
Yes, it's the proposal we have with the 4-bedroom group home and the 2 units on the second floor is consistent, or it's exactly what's written in the master plan amendment.
And that's based on you, as a planner, having reviewed all of these documents prior to this testimony.
That's correct.
So walk us through now the second aspect of this FAR, and that has to do with, I think you've established and you've explained what the reasons are in meeting the requirements of this of these agreements. You know what the litmus test is for an FAR. It's contained in the Borough Planner's report of May 17th, 2024, on the eighth page. Do you concur with that analysis as to what must be shown?
I do.
Okay. And on the basis of that, is it your professional opinion as a planner that the special reasons exist for granting the variance in this particular instance?
They do. In fact, I think I've covered that.
And just at this point, to wrap that part up, would you just give us the bullet points as to the special reasons?
You're asking for something. Okay.
It's right here.
You got that?
I have it.
Thank you.
We're referring to Ms. Ryder's report. I don't think we've marked it yet in evidence.
I wouldn't have, no.
I don't think so. I think we should mark it since he's referring. So let's call it Board Exhibit 1.
You said May 17th, correct? The May 17th
Yes.
May
report?
17th.
Just
May 17th.
confirm.
Specifically, we've established that we meet the special reasons in terms of that it's promoting the advancing of purpose of zoning in terms of MLUL 4055D2 for the purpose of the act. Specifically, as I mentioned before, this is a inherently beneficial use, and it specifically meets the purpose of the zoning with that. And in terms of the D4 variance case must show that will accommodate the problems associated with the FAR, which is larger than what is permitted in the ordinance. Again, I've gone through that and specifically talked about the problems associated with the lot in terms of, in my opinion, there is no problems associated with that FAR because the lot can accommodate it with the size of the lot and in showing that it meets all the requirements of the setbacks and the coverages and the like. And lastly, the applicant must also satisfy the negative criteria in that the proposal will not create a substantial detriment to the public good. And in this case, we're meeting the requirements of the master plan specifically, and the proposal will not create a substantial detriment to the zone plan or zoning ordinance. In this case, it cannot because we're providing exactly what's in the master plan amendment.
And in essence, and as far as the last part of the litmus test, we are complying with what's required under the master plan and under the agreements that were promulgated and agreed to between the applicant and the Borough of Oradell.
That's correct.
The report of May the 17th also recites what permitted uses are in the site, on a site itself, and that's referenced in this report. And you agree with the fact that this use that we are proposing fits within the requirements of the ordinance as far as use is concerned?
That's correct. The proposed group home is considered a single-family home in terms of the MLUL requirements, so it would be it would satisfy that requirement.
So, page 5 of the report states that uses permitted in the zone can include community residences specifically permitted by state statute. And it's your opinion as a planner that this fits within that requirement.
That's what it just, yes.
Thank you. This concludes our direct testimony at this time.
Thank you. Before I turn this over to Carolyn, hearing that you could have two structures by subdividing, have you considered the possibility of actually using two structures, say one with bedrooms and other items necessary for the living space of the residence, and another for the common areas?
No. No, because then it would not be, in my opinion, it would not meet the requirements of a group home.
Right. It would
You'd
not,
be separating them out, and you'd have
Yes.
a single-family home and a single-family home, so you'd have two single-family homes.
In effect, but would it meet the needs of the residents?
No. The supportive housing units have to be next to each other. They cannot be separated.
Okay.
If you separate them, now you'd have to have a separate parking area other than that, staff. It couldn't work.
Okay. Just anytime I hear something can be done and not require a variance, I'm curious about that. Thank you. Caroline?
And also to add, I'm trying to pull this a little closer. To add to that, wasn't there also testimony that the apartment, the independent units on the second level, and will have a relationship with respect to the group home in terms of some of the common areas as well?
That's
Wasn't there
correct.
testimony to that, I believe, from the United Way representative?
that was testimony from Mr. Toronto at the beginning, yes.
So they're not meant to be. There's maybe synergy is not the right word, but there is some sort of relationship between the two.
The relationship to this is actually the community room that's involved, and that's what I was trying to say in my testimony. They're specifically, these are all tied together. Those units up on the second floor and the units on the first floor is one, while they have maybe separate living areas, they are all tied together with the providers and everything else, along with the community room. They have to be connected together.
And that's a requirement. It's not just a wish, it's a requirement. Our proffer in showing you the two lots scenario is to show you that at the end of the day, you have more square footage of building than we are
Yes.
proposing.
No, understood. That was obvious. Thank you. Caroline?
Going back to that, the thought of the two lots, was the concept of this two-lot analysis, was that just a relationship with respect to there's sufficient area for a subdivision? Did you go any further with respect to lot width, lot depth, or just the analysis with respect to area and the resulting FAR?
Specifically, we could not fit the group home within the area. If we subdivide the property, and the smaller lot would be on the left, the larger lot would be on the right. I did look at it in terms of, could it be done? And the simple answer is no, we could not fit the group home in either one of the remaining lots.
Okay, thank you. With respect to the size of the group home, you testified that this is one of the smallest group homes that could be permitted to be constructed. Wasn't there also testimony that the size of the group home was dependent upon certain storage requirements, and that also made the home a little bigger? In fact, I'm recalling that maybe between two of your meetings there were revised plans that indicated storage space, and I recall that because there was it wasn't clearly as labeled on the plans, and I was uncertain what that was. It was labeled in red ink and handwritten, and we asked the architect, and he indicated that was storage space, but it was a little unclear where it was going at this point in time.
Yes, I believe the architect had testified after we've gotten some public comment from during his testimony. He did go back and do an analysis of the group home and determined that that's what I believe the storage area was increased in size or something of that nature he had done inside, but he ultimately came up with this is the smallest size group home that he could put in this location.
And so the record's clear, the smallest size group home to meet the requirements, the state guidelines and requirements for the group home.
With respect to you provided an alternate parking scheme tonight.
Yeah.
So it's your testimony that the applicant has no preference, but the purpose of this is to show that that the same number of spaces could be provided, and it's your testimony that it would be variance-free with respect to the coverage variance. That would eliminate the coverage variance.
I believe it does not require any variances for the alteration in the design of the parking area as shown. Number one, it eliminates the coverage variance. I don't believe it requires a variance for the location of the parking to the front yard. I don't believe it does. But I believe that what we provided here would be a variance-free application in terms of the coverage.
In terms of the coverage.
Yeah.
So obviously we're all seeing this for the first time
Absolutely.
tonight, so we'd have to take a look at it offline and confirm that. But do you think this offers a better alternative to the residents that might be in the area? As you're aware, because you've sat through all the meetings, there is significant resident concern about this application.
It would certainly provide a little bit more buffer to the two residents on Garden Court. I guess those would be the only ones that would have beneficial, and that would be the properties to the southeast of us or east of us. North is to the left.
Would there be with the lighting?
In terms of you have to remember the lighting that we're providing is bollard lighting. We are not providing anything taller than, I think it's 42 inches, a 48 inch, I think they're 42-inch lights. They're very low, and with the intent of only lighting our walkways. We are not intending to light up the parking lot. This is not a commercial, we're not trying to be a commercial parking lot. We're very sensitive to this is a residential use, and we want it to be a residential parking lot. Or a residential lot to park cars.
Mr. Chairman, respectfully, I would recommend, if the board agrees, that Mr. Atkinson and I maybe take a look at this, after the meeting, or that this option be looked at and considered with respect to this application.
Certainly.
Of course, it's the board's decision, but I think that
We would certainly like your professional opinion, and this case will be carried on. Fire department agrees.
That's the end of my testimony.
that's how good they thought it was.
And we're not closing the windows, so let's just...
It's warm in here.
Is that... do you have any further questions?
No, I was just going to suggest. I have a feeling, as was indicated, we're not finishing tonight.
We're
but
not finishing tonight.
I think that it would make sense for us to take a look, or I would like to at least take a look at this
Of course.
offline, because I think that there might be some benefit to the residents, although, as was testified, that would result in the removal of trees, additional trees. So I think that there's some positives and negatives. But
Again, as I said before, whenever we can do something that means we won't require a variance, I'd like to know why we need the variance.
that's why I'm suggesting it, right? So,
Yes.
My report also indicates some goals of the master plan that I identified with respect to the application. I understand the housing element and the amendment, which we prepared in 2022, which includes this property, was testified to, but there's also some goals with respect to the master plan that was prepared in 2018, one references special needs housing, one references enhancing areas of stability, encouraging a proper distribution of land uses by designating areas with their own uniform development characteristics, preserving the residential character, existing density, by restricting incompatible land uses and building heights from established residential areas, and limiting intensities of use to the levels, locations prescribed herein. And then there's the last one is providing a variety of residential housing types and densities and a balanced housing supply in appropriate locations to serve the borough and region.
while I didn't specifically mention those by reading them and explaining that those are the goals that we meet with the master plan, we actually do in terms of every one of that you mentioned. Specifically, we've taken care in terms of with the building height, with the types of housing that we're providing here, and also and specifically about the land use types that we're proposing here are consistent with the residential zone.
We stipulate that we
We're done.
concur with the analysis that was done in the May 17th report.
Thank you.
Mr. Chairman, I don't believe I have any more questions at this moment, but in light of the fact that Mr. Hall's coming back, I might have further questions at the next
Certainly.
meeting.
Okay. Dave?
Sure, I don't really have too many related to the planning, just related to the exhibit. As far as maneuverability in that parking lot, in the exhibit, that's A14, is there sufficient movement in there for particularly, I guess, the last parking spot on the left?
That's correct. The last parking spot on the left would be a little bit difficult to maneuver in and out, but it's for our use, and it's not a parking lot for transient use.
Okay.
So there might be a little bit more difficulty to get in and might take an extra turn, but they can get in and out of the space.
Okay. I guess,
We might label it as the employee parking.
okay. But typically, if you were to design it for more commercial use, you would provide a little more space.
If it was for commercial space, I would provide a turnaround area, absolutely.
Okay, fair enough. I have no other questions.
Thank you. Steve?
Nothing, Chairman.
Bob?
I have no questions.
Okay. Any member of the board have any questions?
Does the new plan move the trash enclosure?
No, the trash enclosure is still located in the right rear corner of the proposed building. With the exhibit that's on the screen, that was an earlier iteration of the proposal. We moved the trash enclosure. The one that I have mounted is the proper plan. That's the one with the trash enclosure next to the building itself. That was just for cans.
It's shown on A14.
Okay, thank you.
Any other questions from the board?
Yes, one question. With regard to the total floor area ratio, if for some reason the United Way down the road chose not to operate this property or continue to operate the property, what control does the town have over other permitted uses of this property and the potential for total residence in the property?
The answer would be none whatsoever based upon the agreements that have been entered into between the applicant and the borough. But I would let council
controls.
confirm that.
There would have to be a modification of the agreement, which would probably be impossible.
Yes, because this is factored into your account.
It's part of
into
the
the account as your
affordable housing plan.
requirement. This was promulgated based upon the affordable requirements that you had in round 3.
Right.
Yes.
Part of the approved affordable housing plan for round 3,
Thank
with a judgment of compliance and repose issued by the court, and relying in part on that provision in the settlement agreement.
In the settlement agreement, and you have these as part of your exhibits in your packet, that's the application. This was not only contemplated, but required for the settlement purposes
Right.
of the litigation with the borough. That's why this was entered into.
Okay, do we have any other questions?
I just have one question.
Sure,
Mr.
by all
Chairman.
means,
Just,
sure.
I knew I had something here. In terms of the subdivision with the property being subdivided into 2 lots, you said the current proposal is for 5,930 square feet floor area. The 2 homes, if constructed, would total, I think you said 6,100 and change?
6115.
6,115? Okay. That's all I have. Thank you.
Thank you. All right. This is the point at which the public gets to ask questions. Please, hold on a second. Just keep in mind that it's only a time to question the witness on the testimony that has been given. This is not a time to enter into debate. It's not a time to tell us what you think of the project or anything else that's not relevant to the testimony that you've heard from this witness. Now, first, do we have any attorneys representing clients? I'll look for a show of hands. We do, sir. If you would come up, state your name and whom you are representing.
Mr. Chairman, members of the board, good evening. Good to be back here. Again, my name is Rob Simon. I'm an attorney with the firm of Herald Law. I'm here on behalf of 4 sets of property owners. I stated them last time. I can state them again,
It's
Mr.
not
Chairman?
necessary. Did somebody say something? No? Okay. It's not necessary. It's on the record already. Just a reminder, they do not get the opportunity to ask questions because you're doing it on their behalf.
Understood. I do note that it's almost 8:30, and I do recall that,
It's 8:25, and you would have up until 8:39.
right. So here's my question. It's up to the board. I have many, many questions from Mr. Halls as a planner. I will not certainly finish this evening, so it's up to the board if you want me to get started. I'm happy to, or defer to a member of the public.
Well, you have 14 minutes unless you feel you're unable to get started on this. By all means, start, and then the witness will be back at the beginning of next meeting.
Absolutely get started. Yes, thank you. Mr. Halls, good evening. Good to see you as always. So with regards to your testimony as a planner, have you testified as a professional planner on behalf of group homes in the past?
I don't know.
You don't recall, as you sit here tonight, this could be the first time you've testified as a professional planner in support of a group home application?
Most of the group home applications that I've done are as of right, so we don't necessarily, I'm thinking of how many group homes I've done in the site plan approval.
So again, as you sit here before the Oradell Board of Adjustment, you don't recall one situation where you provided professional testimony, professional planning testimony in support of such an application, correct?
No, I'm not saying that. I'm just saying I don't recall. I probably,
Perhaps we could hold that
I
question
don't
in
know.
abeyance and he can check his records.
More than fair, Bruce. And you commented about the community room. So the community, what's the size of the community room?
I don't know.
That's not testified, it was testified to by the architect.
Well, he testified, Mr. Whitaker, earlier this evening that the apartments and the 4 units, bedrooms on the first floor are going to share a community room. And I'm asking, I was part of his planning testimony, and I'm asking him a question about the size of the community room, if you know.
I don't know specifically.
Okay. Do you know anything about the...
I'm please be
sorry,
careful
Mr. Chairman.
about the microphone when you're
I'm
answering the
sorry.
questions.
Other than the testimony that has been provided in support of this application to date, are you independently aware of any use or functionality associated with that community room?
I don't understand your question.
How is the community room to be used? Do you know?
The internal workings, I'd have to guess, so I'm not going to answer that.
Okay. So you don't know the extent to which someone who would be residing in one of the apartments on the second floor would be utilizing the community room, correct?
I don't have any specific knowledge about how they
That's fair.
internally work the system.
And Dave, I think you said in response to Bruce's questions, getting you qualified, you reviewed the ordinance, the master plan, correct?
Yes.
For this application. Regarding the master plan, do you recall the recommended density for this particular lot as stated in the master plan?
The amendment that I mentioned before?
In based on your review of the master plan, and when we say the master plan, what master plan did you review, Mr. Halls?
I reviewed both the master plan and the amendment to the master plan from 2022.
Okay, and then when you say the amendment to the master plan, you're talking about the housing element and fair share plan?
Yes.
2022?
Yes.
Okay. Based on your review of the master plan and the master plan amendment from 2022, do you recall what the master plan says as to the recommended density for this lot?
No, I don't remember that one specifically.
And I asked you when you were testifying as an engineer about whether you had reviewed any elevations of this building, and my recollection is that the only elevations you reviewed were a colored rendering that is part of the record for these proceedings. Between your testimony as an engineer and this evening, did you have an opportunity to review any elevations prepared by an architect for this building?
Everything that was submitted is what I reviewed.
Okay, did you recall, because I didn't see any elevations, do you recall reviewing any elevations for this building prepared by a professional architect?
I believe he submitted a rendering.
A rendering, but that was it.
rendering
But you don't know what the rendering was based on, correct?
You'd have to ask the architect that question.
Also, in terms of some housekeeping, last time I asked you whether you had any knowledge as to the notation on the tax map, the borough's tax map for this property, where it specifically denotes parking on this lot. Do you know anything about that still?
I still don't know anything about that.
And you still haven't done any type of a review to title search regarding this property, correct? In your role as a professional planner?
Well, and as a professional planner, no. As a licensed land surveyor, yes. As an engineer, yes.
Okay.
Which one do you want me to wear?
Okay, but there was nothing in the title search that you felt was relevant in your review of it in your role here as a professional planner providing planning testimony, correct?
No, I don't believe.
Okay. And did you, as part of your review as a planner, look at the any DEP or related information as to the location of threatened or endangered species on this property?
There are no freshwater wetlands on the property, and I did walk the property nearby. I did not see any observable wetlands within 150 feet of the property.
Okay, I didn't ask you that. I asked you, are you aware of any mapping promulgated by the DEP or otherwise that depicts that this particular lot contains threatened or endangered species?
Again, I would answer the same way I just did before.
The answer is no? You're not aware?
I'm answering the same way.
Other than your wetlands walk, correct?
That's the way I would answer the question. I'm sorry.
Okay. With regard to the apartments on the second floor, each one has an independent living area, correct?
Yes.
And do you know what that living area is intended to be used for?
Well, they're supportive housing units.
For the apartments. I'm saying just the apartments on the second floor.
Again, they're supportive housing apartment units, as you're referring to them.
Mm-hmm.
I'm calling them supportive housing residential units.
And so it's a kitchen area?
The answer is still yes.
Okay. Living area with a couch and a TV?
Yes.
And other than the community room that you referenced earlier this evening, is there any other functional connectivity between the first floor group home area and the second floor apartments, to your knowledge?
I believe it was testified by both the architect and Tom Toronto on the functioning of the unit, and they described it as the community room.
Okay. Other than that, you're not aware as a planner of any other common functionality between the first and second floor?
I'm going on the basis of the testimony.
That's fair. With regard to your testimony this evening that this property is shallow, it's certainly wide enough, right, to meet the ordinance requirements?
I did describe it that way, yes.
Right. Do you know, Mr. Halls, I'm referring to A14, what the distance is between the parking space that's on the, I'll call it the top right, the one furthest away from Genther on the right, and the property line?
It's dimensioned as 3 feet.
3 feet. So 3 feet between the property line and that parking space, correct?
Yes.
Okay. And you also talked about the fact that you were considering A14 as an alternative, and the reason why you didn't propose it in the first place was that you were concerned about preserving some trees, correct?
That's correct.
And so, first of all, can you just identify, and I don't know what plan, Bruce, this is up here on the screen?
The other plan, that's the original plan.
The original plan. So are the trees that you're referring to the ones that are in the front right of the drive aisle as you're entering the original parking area?
That's correct.
And do you know what type of trees those are?
Probably.
Okay.
I know what they are.
As we sit here, you don't recall.
Okay.
Okay.
Yes.
Okay.
They're
So-
labeled on the plan.
Right. So but you don't recall the diameter breast height or their
They're
current
labeled
height?
on the plan.
Okay. I also recall on the plan that there was some grading and area of disturbance shown on that plan, correct?
Yes.
Okay. And so did he do an analysis, and maybe this is something to Ms. Ryder's point in terms of checking offline this A14 plan, as to the extent to which grading as part of construction activities, if A14 parking area were constructed in lieu of the originally proposed one, how that would nevertheless impact the existing trees that you otherwise intended to save. You didn't take a look at that, or you
I
did?
did take a look at it. I
Right.
believe it's going to take, we'll most likely remove 3 of the 4 trees.
So, on the original plan, you were going to remove 3 of,
No.
say it your way.
The original plan proposed to keep those 4 trees.
Correct.
The intent was to keep the 4 trees.
Yes.
The alternate plan, we would have to remove at least 3 of those trees.
So 1 tree would stay and 3 trees would be removed.
Potentially, that's correct.
Thank you for the clarification. Did you,
Yeah, but that's not it.
I got 30 seconds. I'm going to ask one more question. I'm going to stop. Parking location, even the parking location, via A14. Did you consider flipping the parking location so that it would be located on the northern side of the lot as opposed to currently the southern side of the lot?
Well, it would actually increase the impervious coverage on the property if you did so, because the entrances to the building are on the right-hand side. So now you would have to have a walkway completely across the frontage of property. You would end up with a larger disturbed area. Larger impervious coverage or lot coverage. So you would far exceed the lot coverage.
Okay. Mr. Chairman, I'm a rule follower. 839.
Okay, good. Thank you. Yes, we'll begin next time with continuing your questions. All right.
Thank you, Dave.
Chairman, what's the next date for?
The next date is November 18th. So we're going to.
Application will be carried to November 18th without any further notice.
Thank you. Yeah, I was going to say that.
Sorry.
At 7:30 p.m.
7:30 p.m. Yes, we'll begin with your case. All right. Thank you. With
Thank
that,
you, Mr. Chairman, members of the board. Have a nice evening.
you too. I'm going to call calendar 882-24, Curalta Health LLC, 680 Kindercamack Road.
Maybe people don't realize that. The other one, maybe people don't realize it's out there yet.
Maybe. I'm more interested in the package.
One of those retail spaces. It's so nice after work. I mean, not that the town has any liquor licenses, but the dimensions didn't look right, that kind of thing, but.
Everybody.
They're gonna get a lot of office.
See you next month. Dave?
And I don't like that. That was my bank.
Deposit blocks, they weren't saying if it was.
My husband was supposed to go to the game.
I got my letters telling
The
me.
one that would have been, actually tonight. But it wasn't
Get my stuff out
necessarily,
of the
didn't
box.
materialize. Not World Series, obviously, playoff.
Yeah.
The Mets.
No, Yankees. He's a Yankees
Oh, yeah,
fan.
okay.
But it
Although
was,
he's, even though they made it to the World Series, he still
some
says they're not good.
I was like, what's going on? Is it open? Is it closed?
Okay.
No, I bank at Wells Fargo, but I use.
Oh, yeah. Do you want to let him know to come back in?
Oh.
Yeah, we don't.
Talk
We've
about
got a
being
couple
in
of board
limbo. They've
members.
been-
Yeah.
I have no,
We're going to try to take a break
Nothing on
at
this.
9 o'clock, so I don't want to interrupt the flow of anything, so...
I think we can get, depending on the amount of questions, we can maybe even get through one witness by
was I supposed to
Okay.
review this? Is this,
yeah.
it's a D2?
Yeah, I won't
It's
interrupt the
expansion
flow of things, but
non-conforming
I
use,
would
we
like
gotta
to...
do. Not one problem.
isn't it? Yeah, then it's a, yeah, is it the D1 reopened?
Yeah. Okay, anytime you're ready.
One, isn't it? I'm gonna get
Mr. Chairman, good evening, Mr. Chairman. Andrew Kohut, K-O-H-U-T, Wells, Jaworski, and Liebman, 12 Route 17 North, Paramus, New Jersey. Here on behalf of Peralta Health LLC. Property is 680 Kinderkamack Road, Block 807, Lot 2. Property's in the B2 zone. What we're here for is it's a little bit of an interesting application. In 2007, there was a use variance approved by this board for this property that approved a medical facility, medical office with ambulatory surgical center, imaging center, and various other medical uses. And one of the conditions within that approval was that there could be no overnight stay. Patients of those tenants could not stay overnight. However, in the property, the B2 zone, professional office permitted, medical office is permitted. But I believe by me reading the resolution, there was a sense they didn't want this turning into a quasi-hospital. Was I think the gist of that application. Maybe some of these board members, you were at that.
I was on the board.
On board at that time, so you could confirm that. So what my client is here for is to occupy 4,400 square feet with a clinical for a clinical trial department. In essence, what happens is they have post-operative pain management for elective procedures. There's no medical procedures done on site. Everything is off-site for elective surgery. Things like bunion removal is one example. Mr. Gerritz, the witness, will give more information on that. They come from the surgical center or wherever they're getting the procedure done. They come here for the trial. One of the things that the participants do is, because they're managing pain, what they're trying to use is non-narcotic pain management. Given what the opioid crisis is today, they're trying to come up with non-narcotic pain relief. So what happens is they need to stay overnight. Some of the participants need to stay overnight for the monitoring to make sure that they're not taking any other type of medication, and then they can monitor the process. Again, no medical procedures are performed. The only thing that is done is if a wound care or an injection, if that relates to the type of pain medication that's being provided to the participant. When my client came to speak to me and he was describing the use to me, I thought of for those who snore like myself, they have the sleep monitoring facilities where a person will sleep in a room overnight and they monitor their sleeping pattern. Similar type of situation here. No visitors. Person stays. They leave on their own. No ambulance will come and take them to wherever they need to go. Someone will pick them up, or if they've driven to the facility, they'll leave. They're asking for a maximum of 3 people to stay overnight. You'll see in the site in the plan there's 4 rooms. That's just for convenience. They're looking for 3 participants to be allowed to stay overnight. Unless the board has any questions of myself, I'd like to call my first witness. Thank you, Mr. Chairman.
Sir, would you raise your right hand, please? You swear or affirm that the testimony you will give in this proceeding shall be true, so help you God.
I do.
And for the record, state your full name, please, and spell your last.
Jeffrey, Gewortz, G-E-W-I-R-T-Z.
Could you spell that again? G?
G-E-W-I-R-T-Z.
Okay, thank you.
Mr. Gewertz, for the board's edification, your background?
So I'm the current Chief Medical Officer for Curalta Foot and Ankle. I've been practicing podiatry for over 20 years. I previously served as an Associate Residency Director in the city. I currently oversee over 70 doctors and over 40 locations of practicing podiatrists. I've also been working with my Clinical Research Director who serves underneath me. I've known him for 25 plus years, and I've been working directly with him for over 10 years, and we've been overseeing research trials.
Okay, and who is Curalta?
So we are a multi-site, single-specialty podiatry practice. We provide care specifically.
I'm sorry. He said
you're
you're
going
going.
very fast.
Yeah, I'm sorry. Multi-site, and then that's all I got.
Sorry. We are a multi-site, single-specialty podiatry practice. So we practice care of the lower extremity, specifically the lower leg, the foot and ankle. We perform the treatments of patients, evaluation of them, and we work to advance the profession and the advancement of medical care of our patients.
And you currently have locations throughout Pennsylvania, New Jersey, and New York, correct?
That's correct.
Okay. So with regard to the 4,400 square feet you're going to occupy, why don't you walk through the board what the proposed use is?
Sure. So we have patients that come in for studies. There are all different types of studies. Specifically, what we're requesting for is patients will come in and have.
Just going to turn it the other way, I'm sorry.
Okay. Sorry. We have patients that will come in to have an elective outpatient procedure. They'll be evaluated. The procedure is the vehicle to study postoperative pain medication and its effectiveness. Specifically, we're evaluating the effectiveness of non-narcotic pain medication after surgical procedures. So the patient's going to come in, they're going to be evaluated. Do they meet study criteria? They are electing or choosing to have these procedures. And then the surgery is done at a surgery center or a proper facility. No medical procedures are done within our study center. The patient is then monitored overnight, like Andrew said, basically similar to a sleep study center where the patient had the procedure elsewhere. They would otherwise be able to leave on their own, go home, and recover without any care. They're coming in for a short period of time, usually somewhere between 24 and 72 hours, to be monitored. Some people will be given medication, specifically study medication. Some people will be given a control, so they may only get like Tylenol or ibuprofen or something like that, and we are monitoring at intervals how they're responding to the use of this pain medication. When you do a study like this, you have to have tight controls over the patients. So you can't say, oh, go home and we'll monitor you at home and you tell us how you're doing. You really need to strictly manage studies to make sure that the patient is staying within the guidelines of the study so that there are no outside medications or anything outside influential. You don't want somebody to wake up at home and have really bad pain and decide to go and take the Tylenol with codeine they got for their wisdom teeth because it's not being controlled. We have to manage them and monitor them. There's no care being given whatsoever. It's really just maintaining them in a controlled environment so that we can truly know the effectiveness of what we're studying.
What I wanted to go over and what I thought would be important is, again, you touched on it a little bit in what you just described. Who are your participants in the study? Why don't you walk the board through that?
Sure. So people are electing to be in any study. We have patients coming in who may be referred by other providers, may have seen an advertisement, may have heard it through word of mouth. And these patients are electing to have to be participants in whatever study there are. So there's no one forced ever into this. These patients are choosing to go ahead with this. So an example is a patient sees that we're offering a bunion surgery. They get paid to have their bunion surgery, so now they don't have to go through insurance. This is truly outside their medical insurance. This is not a managed care kind of situation. And so they then get to have this elective procedure they've been choosing, and they're then going to recover for a short period of time initially after their surgery at the center, just relaxing, watching TV, and answering questions about how they're doing with their pain. The patients and they're really not patients, they're patients, but they're really participants in a study. We don't want to think of them as patients because these are not people that called and made an appointment because they're having a problem. These are participants in a study. They are choosing and electing to come in and have this performed.
And I think the key when you say patient, they're patients off-site at another medical facility that performs the procedure. They're coming here just to participate in the study, correct?
That is correct. Yeah. So the patient will elect to be part of the study, and then they're going to return back to whoever their medical doctor is for whatever care they need. So in terms of podiatry, there may be a podiatrist within our group that identifies the patient as an ideal candidate for the study, who wants to have bunion surgery, and you can say to that patient, I think you would be a good participant in the study. Why don't you contact our study group, our research arm, and then they will go in and be evaluated and move forward. And then once that procedure is done and they've completed the initial recovery of monitoring the pain management effectiveness, they will go back and return to their original doctor.
And I had indicated that the only type of care that's provided really is there could be a possible, if it's an injection study or a topical study, correct?
So no medical procedures will be done. The types of things would be done in the case of any study are no different than any other medical office. So anything that a doctor could do in their office is like we would do. An example would be is we're doing an injection to evaluate the effectiveness of some sort of medication on an arthritic condition. The patient would come in, they would get their injection, they would leave. You have to think of it as no different than you go into your primary care provider and maybe he gives you your flu shot and then you leave. It's pretty similar to something as minimally intrusive as that.
And these participants are otherwise generally healthy, correct? We're not talking about major medical procedures, quote unquote major medical procedures.
No.
Correct?
No, all procedures that are done in order to enroll in the study are elective outpatient procedures, no different in severity than like having your wisdom teeth pulled or having a colonoscopy.
Okay. And then as far I had discussed about ambulatory services, is there any what is the extent of the ambulatory service that happens at your use?
There's no ambulatory service provided. The patient is going to have the procedure wherever they have it, whatever surgery center we use. They will be brought via some sort of ambulette because we have to control the transport of the patient. Again, we can't have somebody leave the OR and then stop and pick up medication or decide to go out and have breakfast and have a drink at the bar. So they have to get transported to the research center and stay there. It's usually via ambulette, like in a wheelchair. These patients can walk. It's more that we want to just protect them because they just did have a procedure, and then they leave on their own when they've completed the study.
And let's just talk about a little bit of the specifics of the use itself. Are there any? Is everything done by quote unquote appointment?
Yes. There's no walk-ins whatsoever. You have to be screened on the phone before you're even welcome to come to the study center to see if you meet the minimal criteria to be a participant in a study.
Okay. At peak times, how many staff members are on location?
So at most we'll have 6 to 8 people working there in a combination of research directors and coordinators, and sometimes some people that are monitors from the outside studies to make sure that protocol is being followed.
And what about the maximum number of participants?
8 to 10 at most, so basically 3 people may be sleeping there, and then you may have somewhere between 5 and 7 people between waiting in a waiting room and being in the other treatment rooms.
But you're only looking at 3 people overnight, correct?
Correct. At any given time, we don't expect to have more than 3 people sleeping in the facility.
Any visitors allowed?
No, the only people that'll be coming and going would be the people monitoring the patients where there may be a shift change at night. And you're talking about one person shifting in the middle of the night and nobody else coming and going.
What's the time frame for people to stay overnight? What's the range?
It's generally 48 hours, so it's usually a 2-night stay. They come from the surgery center, they stay that first night, they're monitored all day the next day, they stay that night, and they get up in the morning and then they go home.
Okay. How is medical waste handled?
We have to follow the standards for OSHA, so we have standard pickup according to the laws, which is minimum of twice a year. There's minimal medical waste because we're not doing any procedures, so we're not doing anything that's going to require major cleanup or major waste. So we follow the standards of OSHA guidelines and the state.
And deliveries are typical deliveries for an office use, a medical office use?
This office will follow the same sort of cadence as a regular medical office in terms of deliveries. So your Amazon driver, your WB Mason driver, or Staples, and UPS and FedEx coming with shipments. But other than that, there's nothing exceptional being delivered.
And then one of the things I found interesting when you were talking to me about this, what type of state approvals do you need?
So by the way, pardon me, the first thing to go is your eyes. So we actually went through the state health department, and we were determined, and we have a letter that,
we can provide a copy.
We can provide a copy. We are not required any licensure for this. In fact, what we're doing is considered to be has less requirements than a sleep study center. So we have a letter that determined by the Department of Health that we do not need any licensure or certification for this.
Okay. And then finally, you and I had discussed what's the benefit of these type of studies? What type of service are you providing to the general public?
So I think this is where the most important aspect of what we're doing comes into play. We're really trying to benefit the public health. All surgeons have really had limited options for postoperative pain medication other than narcotics. We're all aware of the opioid epidemic, an overdose epidemic, and very often opioid abuse starts after receiving opioids for post-op pain medication and pain management. And we're trying to study for the betterment of the public health the use of non-narcotic substitutes for immediate post-op pain management. In the first initial periods after surgery, that's when it's the highest level, bless you, the highest levels of pain, which is when narcotics are used, and that leads to drug-seeking behavior because it can become addictive very shortly after. We have had within our own communities opioid epidemics, overdoses, and we're looking at this as a very serious health problem, and we're trying to do studies to try and better the public health and reduce the opioid dependence and therefore the opioid epidemic.
Okay. I have no further questions, Mr. Chairman.
Okay. Well, it's 8:57, so we'll take a 10-minute break and then begin with questions. So 8:58, be back at 9:08.
Just plug right into that.
Yeah. How does this space?
Well, basically, what you can do is just run everything from there.
They could do this. I didn't know she was leaving.
I've asked her.
So whatever plans you want to show, because
And again,
The question is really,
the press report.
Yeah.
however you want to do
Saddle
it.
River. Whatever you want to do. Upper Saddle River, which I represent.
I remember towards the end, I used to arrange my travel to not conflict. Actually, in 20
I know
years,
Ty,
Our firm does, I don't. I'm doing enough for night meetings.
you live in
The
Saddle River.
color rendering, which is
If
the
we
architectural.
have it, if you send it
That's
to us.
He's done, yeah, he was chairman of the board.
Yeah, yeah.
But he moved.
It doesn't matter.
He moved to Sound River.
There's no way
He had no house.
Yeah, he lives.
killing my
Associates that are not young.
I know, he told me he was working.
They like
My time is done. My time is done.
I'm on Whitfield Lane too.
It's right off of Chestnut Ridge.
2 new members, maybe 3. I don't know.
Exactly. I'm on right.
That's a nice neighborhood.
Have they found more people?
I don't know. Not that I know. Not that I know of. I've asked and I can't get any answers.
They definitely need a chairman. Yeah.
I like that house. I know that's nice.
Yeah,
I guess they can have it.
I was previously. I was in.
My issue is that if you
And elsewhere in Saddle River.
temporary
Yeah, no, I'm
No, not terribly.
other.
precedent is set,
I just, frankly, it's almost second nature now. Figure out how and
Yeah.
not these.
because reviewing the applications is exactly the same.
Precedents at the building.
On Chestnut Ridge Road, too.
Yeah, right on the corner.
Yeah, they were doing work on that house.
Yeah, yeah. He's got some.
Bob writes the annual report, he does the resolutions. You know, there's some internal communication.
That's probably a smaller house than what he had in Upper.
Oh, yeah, it's small.
Yeah, it's like that.
Once you set the precedent,
Most of it is me thinking about it.
And it's one floor, right?
Yeah, it's great.
I like ranches because I got a bad knee. and a
Does he
bad hip.
have,
I know, everybody says.
do you have the other civil site plans on there if he needs them?
I might put in a little more, when I'm retired, this is
I see a nice
intellectual
ranch right over
exercise.
there.
and
That's what I need.
So that my mind doesn't get total
it
much.
is a office in the building.
I have a contemporary ranch.
Is there a way to put the files on?
This particular property,
There's 130 miles away. Yeah.
any of that or combined with
Well, she didn't want me to retire simply
You don't
because
spend
now
enough
I'm
time out there, and I don't know how much time you spend out there, but every time you say, I never get any time out there.
I spent 2 weeks in the
It's not that much.
that's the issue I have. Once
No,
we're
you
down
should-
of
Use
making
it.
it a
Okay.
that, and the next thing we have a hotel.
Yeah, I know. It's.
Right,
I know.
it's 9 o'clock and we are back in session. So, sir,
Mr. Chairman, I had no further. He actually wanted to add one more quick
please.
fact to the record.
So I just wanted to state that we, as podiatrists, are not the people providing the medications. We are backed by major drug companies like Merck and Smith & Nephew and very large pharmaceutical companies or other health manufacturing companies that are looking to provide level of evidence to get FDA approval for their medication. So we would be one site in a larger study under FDA guidelines. So we have to follow very strict guidelines for these studies. These are not arbitrarily created by us. I just wanted to make that point that we are guided by a much higher power.
Okay, thank you. Caroline, do you have any questions?
Thank you, Mr. Chairman. I actually haven't reviewed this application before tonight, so I have just a couple of things I'd like to clarify. So you said there's no more than 3 patients staying overnight. Is that correct?
At any one time, there'll be no more than 3 patients sleeping there.
And how many staff members would be associated, as well as spending the night?
That will be determined based on the overnight stay would be probably 2.
So 2 staff members, 3 patients overnight, and you indicated it's typically a 24 to 48-hour time frame, but how is it every night of the week? Is it every night of the weekend? Is it one night a week, 2 nights a week, 3 nights a week? It's, how often does it happen?
So the studies are likely to be during the week nights and not the weekends. and it'll depend on the study and the days that we operate. So if we operate on a Tuesday, the patients generally would be staying over Tuesday night and Wednesday night. There may be weeks where we want to do multiple study people, so we may have people operated on Monday, stay over Monday and Tuesday night, and then on Wednesday we may operate and have people staying over Wednesday night and Thursday night. So it's going to depend on the study volume and how long. A study that requires a 72-hour stay, we may only be able to operate once a week, versus a study that only requires a 48-hour stay. We may be able to have 2 surgical days and have more patients enrolled.
So with respect to the study, does each study have one patient and there's multiple studies? Does one study have multiple patients? How does that work?
Each study enrolls multiple patients.
But if they're overnight, not more than 3?
Correct. We will not have more than 3 patients sleeping at any one given time.
Okay. Do you have other locations where where such a program functions, or is this the first?
This is our only research center.
Are there other similar similar type businesses or research centers in the area of which you're familiar?
So there is no other research facility like this regionally, but these specifically for podiatry. There are research centers for other types of studies that would have people staying over, but not within our area of expertise.
So this is specific to podiatry. I might have missed some of the beginning of this, what you had said. I was having a hard time hearing you.
Sorry.
That's okay. So there's no other, I'm sorry, I just want to repeat my question. There's no other research centers regionally for podiatry is what you said.
To specifically, yes, there are no regional centers that focus on the lower extremity, and as in what our realm and our profession provides.
So the patients wouldn't have some type of, say, ear surgery and come to you. It would solely be a podiatry, so the lower function, lower body.
Currently, yes, but there is the possibility that we have other doctors that can do other elective procedures, and we can monitor their postoperative pain. We may have other people as part of our group with other licenses. So, for example, another surgeon could do a hernia repair, and we have a licensed nurse practitioner employed by us, so they're legally allowed to monitor the patient after. But again, we're not providing any care. So we may be doing the bunion surgery because that is relative to us as podiatrists, but we may be enrolled in a study with a pharmaceutical company to monitor the effectiveness of a pain management, a pain medication, but the surgery can be done by another provider.
So, okay, thank you. So if you were in the future to, as you gave the example, a hernia surgery, because that might be something that would happen in the future, there would be a patient monitored post hernia surgery, would that represent an expansion of this research program? I'm just trying to get it. I just want to make sure that I'm understanding, as I'm assuming along with the board, you're saying, so that we're all clear. For example, you're saying no more than 3 patients overnight with two staff members each time in this 4,400 square foot space.
Yes.
So I just want to make sure that we're all clear that it would be my understanding that were the board to act favorably on this application, this would be so stipulated in the resolution, so that should this research facility, be approved and do well and be successful, and then be well known, with drug companies, and then, as you indicated, then there's an opportunity for a hernia surgery. Now you might potentially be looking at 5 people overnight. So I want to make it clear that I want to make sure we're all on the same page with respect to what you're requesting, what the board's considering, and potentially and making a determination on, because I know I'm getting a little confused.
So I'm going to keep it very simple. At any given time, we would have no more than 3 people sleeping in our facility to be monitored for pain management and pain medication within a study. It does not matter what procedure they had electively. We would only have 3 people staying at a given time to monitor them for medication. We will not be providing any medical care.
Okay. And I'm sure that you understand that should the board act favorably, and as I indicated, should your center grow and you wanted to have 6 to 8 people, that would necessitate a return to the board.
It would be a condition
It would be a
of the
condition of the resolution, just like should you need more space, should you have more staff, should you, any of these situations, that's what the approval is being considered. There's a very specific type of variance that's being requested here.
Understand.
Okay, I think that's it.
Thanks.
Thank you.
Dave,
Thank you, Mr. Ryder.
any questions?
Just one question. So obviously they're overnight. They could be here for 48 hours. How do you guys handle food?
All aspects of care are taken care of. We have a kitchen that'll be installed and meals prepared. There's bathroom, they are not allowed to shower, but there's bathrooms available for them to use within the suite. There's a full kitchen and an area for them to eat.
And the cooking will be done by the staff?
Will not be any, everything will be prepared meals, so there's no cooking.
Okay, fair enough. I have no further questions.
Steve?
What is the area used for now?
Previously, it was a medical suite.
So it's vacant now?
Correct.
Because they said, what is sick waiting? It's on the,
So that was the previous site plan.
Floor plan.
The previous floor plan, and we just reutilized it. We did not change any of the language on there.
The only thing that changed, Mr. Depkin, if you look on the right-hand side, we showed where the overnight rooms will be.
I see those. So if this overnight rooms aren't approved, what are you going to use the space as?
Well, it'll be used as a clinical research place for daytime business hours.
Okay, so that would be a secondary variance?
No, it would follow under the professional use.
Well, there's a prior use variance in place from 2007 for a medical facility, and then that coupled with the fact, per your code, professional office, which includes medical offices, are permitted use in the B2 zone. So I think between those two components that we're here specifically for the overnight aspect of the application, because as your denial letter had indicated, you didn't see that permitted in the code, and then also in that same 2007 resolution of approval, it was a condition of approval that would not, overnight could not be a component. So that's what we're here for.
Essentially seeking relief from that condition.
Correct, Mr. Reed.
But excuse me, if I understood your testimony, this is a lesser use. I mean, not use within the municipal
I think
land use law.
it's an expansion of
Yeah.
what was previously approved.
Yeah, what I'm getting at is you don't require any license for this. How is this a medical use then if you're not really medical professionals?
Because it involves medication.
And the fact that you're administering medication
Correct.
means that this is
Correct.
medical use.
Yes.
And therefore would fall within the confines of the previous approval that we had?
I think between the prior approval that approved the medical facility, and again, Mr. Michaelman,
Yes, I know,
you said
I
you were
was there.
I believe the components of the medical of that resolution was that it was going to be a surgery center, and I think those specific types of medical uses are not permitted in the B2 zone, but medical office is. So between those two components, I think the use itself of a, and if a variance.
Maybe I should read from the resolution, which is
Please,
what we're
yes.
talking about.
Yeah.
And it's paragraph I on page 4. The proposed use contains several components that are not permitted in the zone. In particular, while medical offices are permitted in the zone, the urgent care facility, ambulatory surgical center, and imaging center are not permitted in the zone. However, the board finds that the proposal to develop the medical office facility in conjunction with the ambulatory surgical center, urgent care facility, and imaging center renders this proposed facility as inherently beneficial use because it offers synergies to doctors, patients, and prospective patients that is not present in other similar facilities in Oradell and the surrounding area.
Now, is that specific to the surgery center?
Yes.
So they would need a variance for their use?
We need a variance to expand the use to allow the overnight patients.
Yeah. But this is a legal question, and I'm not qualified to give any opinions on legal questions, but is this a medical use?
I think it can be categorized broadly as a medical use with medication. My opinion, yes. Notwithstanding, the licenses are not required for this program. It's unusual. He testified that there's not another facility like this anywhere in the region, at least for podiatry.
Okay. So it's a case of first impression.
I guess so.
But I'm not a lawyer, so I'm not qualified to use that term either.
I was about to say, you sounded like one right there.
I'm just a poor retired CPA, sorry. Steve?
So you have 4 overnight rooms, but you're saying you're only using 3?
Yes, we need one for turnover, so if somebody was to leave in the morning and we weren't able to clean it, we want to have another room so that it's ready to go. If something
So
happens...
how are we certain that you comply with the resolution, if approved?
Just like any condition of any approval, they're bound by it. I mean, there's conditions granted to every approval, and a lot of approvals that you don't necessarily see. You can't look at the property and tell if it's being complied with. If they're not complying with it, they could be issued a summons.
Well, I don't think we want to visit on a nightly basis.
I don't think my client wants to go, if the board so chooses to approve the application, not abide by the terms of the approval. They're just trying to make it from a functionality standpoint as convenient as possible.
Well, there's no other way to schedule and clean a room in time to have another patient come in?
Unfortunately, I can't guarantee that with every study because of the overlap. So we're preparing in case of worst case scenario. That 4th sleeping room may be used as a regular treatment room during regular times, but we want to have the ability so if we have overlap. An example is if I have people that need to leave and they
So why not just say you're going to use the 4 rooms?
Because we only plan to have 3 people stay overnight, and that's all we're asking for.
No further questions.
Okay. Bob, do you have any questions?
I just have one. Do you plan on having a contract with a private ambulance service?
Ambulance service?
Yes.
There's no need for ambulance service.
Well, you say that, but you're dealing with sick people. I mean, we're ill, like had surgery. Bad things can happen.
But what I want to make clear is that if something happens to a patient at night, it would be no different than if they were at home and they'd have to call 911.
Except they're not at home. They're in a facility, the medical facility that is operated for a commercial purpose. They're not a resident of name a street in Oradell.
If that's a stipulation of a board, then we'll have a contract with a private ambulance service. We already have a contract with a service to provide transfer of the patient, so.
I think that's something that the board members should consider.
Yes, I agree.
Good call.
No, I agree. If you have an ambulance that's going to bring them there, in the event they need ambulance service, you can use the same company. I don't care.
We would have no problem with that being a condition of approval.
Okay, if approved, of course, yes. Any other questions, Bob?
No, that's all.
I do again, Chairman.
Sure.
If there's ambulatory or ambulance used, will they be parked there overnight?
No.
Separate service?
Correct.
That's it? Okay. Since people are going to be there for 48 hours, the staff is not going to stay. One person in the staff is not going to stay for 48 hours. They'll be coming, going their normal shift, whatever that is. What will the shift be, and will you be changing shift during the night?
The plan is unlikely to be a shift change. The plan is whoever comes to stay overnight would stay.
So,
let's say 7 p.m. to 7 a.m. would be a shift.
So the patient shows up and the staff shows up and everybody is one big happy family for the 12-hour period.
Correct.
Okay. So
Chairman, I have another question.
Go ahead.
So if it's a 48-hour period, what do these patients do, during that time period?
Essentially, the same thing we'd do at home: sit in bed and watch television and read books.
They have
Just
to
had
stay,
surgery.
they have to stay in that room? Is that a requirement?
Correct. Other than for going to the kitchen to eat or going to the bathroom. Again, it's a study, so the environment needs to be very controlled.
So if they go to the kitchen, or is there a menu and it's taken to them into the room, such as a hospital?
No, there'll be available food to heat up. It's not a menu where you're going to order. We'll know if there are any dietary restrictions, so we order food that's able to be eaten by those people ahead of time. But it's all pre-prepared, so all it has to do
Is
is
it like a call and delivery service that will come?
No, it'll already be on site in a refrigerator. The plan is not to have any visitors, and they're not going to be able to call in Uber Eats to bring food to them. Again,
What if a relative wants to visit them
they
at
can't.
night?
No one is permitted. No one is permitted in or out of the facility.
You're saying that a spouse could not see?
Correct. You're enrolled.
Bizarre.
Well, no.
I'm sorry.
You're enrolled in a study, so it's no different than when you're in a sleep center. You go sleep there overnight. Nobody comes and visits you. We have to keep the environment controlled. What if your wife comes and you're like, I'm in pain, and she's like, here, take some Motrin. It just ruined the whole point of the study, and now we don't know if the medication's effective. So just understand that's why it's such a controlled environment. These are FDA clinical trials. If we break protocol, this could affect every person ever to take that medication going forward. It could ruin a study. So the controls have to be very tight.
So these patients are aware of those criteria prior to joining?
They're pre-screened and given all the information before they move forward. There's a phone conversation, so they're fully made aware of everything that'll go involved in the
Are
study.
they compensated for their participation?
They are.
That's interesting.
All right, Steve, anything else? Any other questions? No? No. Okay,
I have one.
yeah, go ahead.
Putting aside podiatry, are you able to give us an example of a similar type of facility in any other medical arena or protocol?
I can't give one off the top of my head. I'd have to get you specifics.
Okay, yeah.
I'm familiar with a sleep apnea center where someone close to me participated and stayed there. I could go visit.
Yeah, I think they
I
have
didn't
one.
go at 2 o'clock in the morning, obviously, but
Right. I think they have one in Fairlawn, if I recall. But
I have one in
There is a research center.
Valley
okay.
Hospital.
Yeah.
There's a research center in Fairlawn. I'm just not familiar if that place has overnight stay.
Okay. Like, I could be wrong. Ask my wife; she'll tell you. You had a question?
Yes, one question. If this were to be approved, would you be willing to limit the overnight stays simply through, say, from Monday night through Thursday night, or possibly Friday?
I think we could limit Monday to Friday night and not have Saturday and Sunday stays. I think we could accommodate that.
Do we have any other questions from the board?
So if you did have participants in a study for, let's say, a hernia operation, you needed a nurse that had a license, so they should probably have to be required to maintain any licenses going forward, I would think.
Wait, I just want to be clear. You're requesting that we have a registered nurse stay overnight?
Well, if you're doing, you gave an example of where someone had a hernia operation, and that particular participant, if they were in a study, would need a nurse to attend to that participant.
No person entering in any of our studies will require any care of any professional.
Okay, but that's not what you said earlier. You mentioned a nurse would need
Practitioner when you were
to...
talking.
No. And let me clarify. We have a nurse practitioner on staff that is able to administer medications to a hernia person, not a nurse to take care of them, just to administer medications because it may be out of our scope of practice. Sorry, let me clarify that. You asked if we would eventually do more than podiatry, and I was giving you an explanation as to how that could happen. Because we don't want this restricted so that it can only be, bunion surgery, because every study may have different criteria for us to monitor the effectiveness of medication.
You wouldn't need a nurse practitioner for, let's say, the bunion study, but you might need it for the hernia study.
Correct, and we have one employed.
So they would need to maintain a license regardless.
They need to
being a
maintain-
nurse practitioner.
Yes, they.
So whatever people that are working on site, they should be required, if they're a nurse practitioner, to maintain any licenses.
Yeah,
I don't know.
yes.
I don't know that we need to impose that.
Yeah, well, actually, I don't think they'd be able to administer medication if they weren't licensed.
Right, but I mean, this approval said a condition of the approval was that any and all licenses be maintained.
Well, yeah, obviously with this type of.
I mean, that was,
Yeah, no, that's going to continue. We don't have to state it again.
Right.
That continues.
Okay,
We can't practice without licenses.
Okay.
but you said earlier that no licenses or medical certifications are required.
No, I was referring to the State Department of Health does not require a special license for the facility.
Special license.
I'm not talking about individual practicing medicine. I'm talking about for
Understood.
the facility.
Okay, thank you.
Warren?
So is the only variance for the overnight stay?
Pretty much. Well,
So
what variances are you requesting?
I was requesting whatever variances were set forth in the denial letter. I could read to you what Mr. Depkin wrote in his denial.
Okay, so we're clear, please.
Proposed medical center with operations and patients overnight stay is not a permitted use in the B2 zone. So
So is it basically you're
I think
asking
it
for
was the overnight stay
The overnight
component.
stay,
Yeah.
yes.
So for purposes of if the application is approved for drafting the
Expansion of
ordinance,
the use variance.
I think I have a list of what the conditions would be. So
Okay.
I'm going to take a stab at it. So it's no more than 3 people staying overnight, 3 patients staying overnight. There's no visitors. There's a max stay of 2 nights.
Max day of 3 nights.
3 nights, okay, max stay of 3 nights. The use is limited to pain management studies.
I don't want to. Yes. Pain medication, I think, would be more appropriate as opposed to pain management.
Okay, pain medication studies. No medical procedures
Yes. Correct.
limited to this tenant? In other words, this isn't an application for this
No,
part of
it's
the building in
just for this
Limited to
building.
the 4,400 square feet.
Correct.
No, but it's not for this space in perpetuity. It's limited to this tenant.
Are you agreeable to that?
Yes.
No?
Yes, that condition.
You are agreeable to that?
Yeah, yes. So for medical procedures for this type of use, pain management study to be done, we'd have to come back to this board to get that approved.
No, but if, let's say, someone else decides they're going to get into this business, so to speak.
Correct.
You vacate the premises, they move in. Would this variance apply to the next tenant?
Usually it runs with the land.
Yeah,
I was just
you're
wondering.
right. I have no problem. That
Okay. Well,
that
that was a question.
no,
I
no.
was-
The question. I thought the question specifically pertained to no medical procedures.
Well, I
That was-
thought that was one of the restrictions.
Yeah, and I said that's fine.
Yeah,
Yeah.
But then my next question is, shouldn't it be limited to this particular tenant?
and that's difficult because we give variances on the land rather than to the individual.
That's fine. That it's part of the approval. That runs with the land.
Yeah, I don't even know if we could impose that kind of a condition. Bob, is it possible to impose a condition just on, for an individual?
Solely to this applicant?
Yes.
It could be challenged, and it
Okay, yeah.
probably would not be upheld. But
Okay. Yeah, I wouldn't favor that. We always do something on the land.
Right.
So they go, another person is in the same business comes in, the variance applies to them.
We have no problems with that, Mr. Chairman.
Oh, Wouldn't think so.
We might be
I'm just,
effectively creating a tenant limitation.
Chairman, what if it goes to another
be so
space?
similarly
Someone comes in and
situated.
wants to do the same thing in another space.
That's what I'm, in another space? There, I think we're applying it only for this space.
They have to come back.
Correct, Mr. Chairman.
Yeah.
I think I heard no walk-ins.
Correct.
Is there a charge for the service? It sounds like they're being compensated, so there's no charge to the patient for the service.
We do not charge the patients.
No.
And that would be an acceptable limitation?
Yeah.
Yeah, we could include that.
And the other one I saw was contracting with a private ambulance service.
That sounds like it.
And Monday through Friday.
And
yeah.
sorry, yes. yes
Well, you
yes.
said Monday night through Friday night.
Monday night through Friday night, yes. Okay.
Chairman, I wasn't clear on the nurse practitioner. Will they be overnight?
Well, from what we heard, if they, I think they probably have to be because they're the ones who are going to be administering the medications. So what we've heard is that whoever is there at 7 p.m. is going to be there until 7 a.m. So
Can
if
I
the
just
nurse
add,
practi-
if medication has to be administered, a licensed professional who can administer the medication will come on site to perform that.
Regardless of the time of day.
Yes, it has to be a licensed professional.
What if something happens during a time period that specialist is not there?
There are nurses overnight monitoring that's there.
Are
with the
nurses?
patient. Yeah, the people that.
Registered nurses?
Yes, there's going to be a professional, licensed individual there on site overnight, not just a random person. There have to be professionals, correct?
Do we have any other questions? All right, now, this is a...
When the people come to get, or when they're leaving, then you'll let somebody pick them, come into the facility or no?
Of course, we're talking, there are no visitors while they're enrolled in the study. Upon completion of the study, anyone can come and get them to pick them up and leave.
Okay. All right. Now, this is a use variance, so I believe we require 5 affirmative votes. Am I correct on that? There are only 6 members of the board present. So if you want us to have 7 members, we'll bring it back next time if you'd like us to vote on this.
We also, if the board requires, we brought with us Miss.
I'm sorry.
Miss Cafone, who's a professional planner, since this is a use variance, to provide some testimony on that matter.
Okay, that's fine. I jumped the gun. I apologize
No
for that.
problem.
However, it's 9:37. You had until 9:40, so you're. Yeah, that's right.
No, let's.
Yes, but you can bill them for it, I'm sure. All right, so if that's it, we will carry this case until November.
Is he a professional or an applicant that needs to be questioned by the public?
Yeah.
Yes.
Yeah, but we're not going to. We'll pick it up with that.
We will all be back next month.
Yes.
So if there's any questions for Mr.
Yes.
Gertz, we'll
Yeah,
let the board know.
we're going to pick it up then. So it is November 18th is the next meeting. We will carry this to November 18th at 7:30 p.m. without need for further notice.
I appreciate your time, Mr. Chairman. Thank you.
Okay. And with that, we've got calendar 883-24, Sir Yo-Yo Realty LLC, 420 Kinderkamak Road. If you would.
Am I in your way?
No, you're
I don't want you to fall or anything.
not even sure. No.
I'm not sure they're getting to you. I think that's highly optimistic.
Yeah.
You see this chairman, he runs everything.
The drug companies?
See you next month?
Yep. Someone from our office.
Oh, there you go. Hi, you too. You too.
It'll reach. Sure. You want to take it now?
I can't provide testimony on that application.
He's gonna take the box.
Get something, have something to review, have some good job. But what do you want me to, do I talk to Marvin about this?
I would. It is okay. They've already been reviewed by the board secretary. I think you give them to Steve.
I didn't say that.
I'm sorry?
No.
Okay, fine.
Yes.
Steve, does he have to press any buttons to get it up on the screen? There we go.
There's nobody here. There's nobody here. I agree with you, though.
This is exactly the Oradell.
I know, it's crazy.
I can play Vanna. Zoom in on that.
You guys don't want to hang out for this?
No, I'm ready to turn this over to the planning board.
You have a reporter? You have a reporter? As you know, it's a D variance.
There's been a bank there since I moved to Oradell in '79.
Okay, I'm done.
That was a historical building. It looks like an old Dutch colony, or did they just build it that way?
No, yeah, no,
They record the meetings.
They recorded on OPTV.
Didn't there used to be a hotel on that spot, like back in the, like 100 years ago?
The Delford, the Hotel Delford, yes.
I know, but
I remember that. No,
Yeah, that was before I
I've
got
aged
here.
really well. Yeah.
Exactly. Whatever you're taking, give me some.
I'm just saying, because of the need for 5 out of 7.
Well, that was the town's original name.
I call it the Ted Williams rule. Kind of little World Series. Ray knows what I'm
I
talking
think your
about.
joke fell flat, Bob.
Huh?
I think your joke fell flat.
You've heard that before,
I
haven't
think it, yeah.
I don't know if it was color.
We have a black and white one.
Yeah,
I said it fell flat, but okay.
you? He's not a baseball fan.
doesn't look any
He
better.
doesn't know who's playing in the World Series.
I do know the Yankees are playing because my husband is a huge fan. That's my daughter.
They won, so
and
we
mine.
can be here tonight. Otherwise, I was going to send a letter that I was not going to be able to make it.
He would have been at tonight's game had this occurred, but it was happening in the World Series.
You're a Met fan?
I don't care.
You're a Met fan?
No.
A Yankee fan?
This would have been the other Yankee game.
I was just wondering which game you were worried about.
I was worried about Game 6 of the Yankee-Cleveland series that
Didn't exist.
would have landed on tonight that fortunately didn't exist. But apparently, her husband had tickets, so I feel bad
Yes,
for him.
my husband would have been attending the game tonight.
Mr. Whitaker was here earlier. He's going to the World Series, he feels.
I was trying to get him to take me with his grandson, but he said no.
Okay.
Bob,
Somebody begin.
Okay.
It's
Mr. Chairman,
9:40.
I advise that the notices are in order and accordingly the board has jurisdiction to proceed.
Okay, thank you. All right, it's 9:42. You've got until 10:42. Go.
Okay, thank you. Mr. Chairman, members of the board, my name is Santo Alampi. I am an attorney in Hackensack, New Jersey, and I do represent the Sir Yo-Yo Realty LLC. This is 420 Kinderkamack Road. It's in the B1 and the CBD overlay zone. I'd ask that we mark the proof of publication and the proof of mailing
Notice document
as
A1.
A1. Thank you, counsel. Is this microphone on? All right, great. So, Mr. Chairman, again, we are in the B1 CBD overlay zone. Everybody's familiar with 420 Kinderkamack. It is on the corner by the park of Oradell and Kinderkamack. There's been a big dispute as to how to pronounce the street in front of it, so
Veldrin.
that's the answer. Veldrin. Perfect. It is on Veldrin, and I always ask because we get beat up when people mispronounce the names in our town, so thank you for that, Mr. Demkin. We are here for a approval of a mixed-use building on the site at 420. It's block 1102, lot 1. I'm sure everybody's familiar with that property. It is next to the post office. It was formerly a Bank of America building. Up on the screen, you see the rendering of what we're proposing, and Mr. Vergona has done, I believe, a beautiful job. I think it really captures the architecture of the town. I think that it mirrors what you'd want to see on that prominent corner. I think it really lines up with
what the CBD overlay district envisions. With that, Mr. Regan, we did not submit the rendering. I will submit the rendering, but I do ask if we can mark it as A2 just to keep the record clean.
Color rendering of what sheet of the site plan drawings?
So it's Mr. Vergona's architectural rendering, and can you send a PDF? I absolutely can. It has a date of March 20th, 2024, and is titled Rendering AR-1.
That'll be A2.
So the relief we're seeking tonight is a use variance as well as a D6 height variance. This application and the required variances is somewhat of a question in my mind from a legal perspective. We've gone back and forth regarding how we got to whether or not a D1 is necessary and a D6. Ultimately, the application had been filed before the planning board and was transferred to the Board of Adjustment sua sponte. There's some correspondence in the package that I'm sure everybody had the opportunity to look at, so I'm not going to beat the horse. It is a D1, it is a D6 as being presented to this board. We do have a professional planner that will go through the ordinance, specifically the overlay and how we get there. I will tell you the issue has to do, as I understand it, with the residential units on the ground floor of the project, as well as how the height is measured under the code and whether or not the rooftop appurtenances get calculated into that calculation. With that, we have 4 witnesses. I will not get through them all tonight, as we all know. Mr. Costa is our engineer, so I ask that we swear Mr. Costa in, and then we'll have Mr. Costa present his testimony to the board.
You swear or affirm that the testimony you'll give in this proceeding shall be true, so help you God?
I do.
And for the record, state your full name, please, and spell your last name.
Absolutely. For the record, my name is Robert Louis Costa, C-O-S-T-A, 325 South River Street in Hackensack, New Jersey.
Mr. Costa's previously been here before and before other boards I represent. I recommend he be deemed qualified in the field of civil engineering.
We do accept you as an expert witness.
Mr. Chairman, good evening. Members of the board, good evening. Members of the public, again, good evening. And Nancy, who's taking the photos of the back of my bald head, I thanked her earlier this evening. Thank you, Nancy. And the rest of the crew.
The microphone.
Oh, this one?
Yes.
That one right here? That's it. Beautiful, thank you.
You got to turn it on, I think.
I think it is on.
What's happened? We'll know.
To start, all right, very slowly. As you can see, the architectural rendering that Mr. Vergona and the team, obviously Mr. Vergona and his office worked on, again, it's the Bank of America building that obviously is no longer there. The building itself is there, but the bank itself has closed the branch there. Our client purchased the property to try to redevelop this site, again, into retail and apartments. You'll hear testimony later on from the various witnesses. The idea is to take roughly 5,550 square feet of retail on the bottom floor and then 44 apartments on the top floor. This is in very close proximity to obviously your train station. Your zoning actually allows it with a couple of caveats, and you heard Mr. Olampi say earlier, you have the ground floor units that under the ordinance is not permitted, and we would need relief from that. In working with this, so basically everything, all of the access would come off of Eldrin.
So, Mr. Regan, we did not submit the colorized rendering that Mr. Costa is pointing to, and that has now been placed up on the screen. So I'm going to ask that it be marked as A3 since it is colorized. Mr. Costa, that is the same sheet that was submitted with your site plan, just colorized?
That is correct.
What sheet number is it? Just
Sheet number 2 of 14. And again, just for the record, the title is Site Plan. Suyoro Realty, Block 1102, Lot 1, 420 Kinderkamak Road.
That's going to be A3.
Borough of Oradell, Bergen County, New Jersey. And it's dated, excuse me, November 17th, 23.
Is there a last revision date on that?
Last revised, May 30th of 24.
Thank you, Mr. Costa.
You're welcome. So basically, just to describe the site, it's roughly almost an acre in size, 0.91 acres. It's on a corner lot. It's adjacent to the post office. Again, all of the access, it fronts Kinderknack Road, Cannon Road, that has no access today and will have no access if this is approved in the future. So by doing so, we're using a little bit of the grade and creating a two-way driveway to the east of the site. If you pull in off of Eldrin, you'll have basically a surface parking lot that'll run underneath the L-shaped of the building, and that'll come out to a surface parking lot to the north of that building. As you pull in, there'll be ADA parking spaces on your left side, and if you go a little bit further, there's actually a ramp that would go down half a level. So it's a little bit like a split level house. So the split will come down. You'll go into what we're going to create as a lower parking area at that section. And basically that'll be underneath the actual building that'll be on top. That's going to be at grade on the Kinderknack Road elevation. So in the front of the property, you'll have landscaping on the Kinderknack Road. You'll have the sidewalks, the ADA ramping, sidewalks around the entire site, and then that'll service the stores at grade level. And then underneath it, as I said, you'll go a half a story down, and that will service mechanical equipment, and then it'll be a split to get yourself into the lobby area for the apartments. So if you came in and you were parking in the underground section that's literally 5 feet below grade, then you would go into that lobby and then go up, whether by elevator or stairs, into the main lobby level that'll service the apartments, and that would be at grade on the outside. So that was the thought process there. We then, excuse me, let me just give you the breakdown. So it's 27 one-bedroom units, 15 two-bedroom units, and 2 three-bedroom units. And then again, 5,550 square feet. So
Give me that breakdown, get 21 one-bedroom, 15 two.
I'm sorry, 27 one-bedroom.
27, because I was not adding up to
Right,
40.
15 two-bedroom and 2 three-bedroom.
Okay, thank you.
No problem. And then if we stay with the parking, like I said, all the spaces are numbered. We have a total number of parking spaces of 75 parking spaces. Based on the breakdown of RSIS, you would require, excuse me, roughly 83 parking spaces for the multifamily, and then using your commercial code in the district, you would then have a total of an additional, 22 parking spaces for a total of 105. And then that breakdown, because of the EV ordinances that are in existence, you actually get a 10% credit. So if you actually looked at the apartments, so basically what we're providing is all of the parking for the apartments and nothing for the commercial, because you would get the actual discount for the 10%. We're putting in EV parking spaces. We're putting in make-ready parking spaces to meet the ordinance requirements. As we go a little bit further, we broke down again the height, and based on your ordinance, because it's in 2 zones, we actually broke it down in both, and that is on your sheet. I believe it's 2A and B, if I'm not mistaken. And by doing so, based on the ordinance with the different... You want me to pull it up? Yeah, if you can. Yeah, I can get to it. Let's go to the next sheet. So, based on the definition of the ordinance, how to measure the height, that's what we did on these 2 sheets for each individual zone that it's in. And then based on the results, you'll see the calculations at the bottom. So you'll see in this case, the existing, the existing is 35.7 with the existing building. Then to the right would be the proposed building height. Elevation 73.5, which would give you a variance because we would need 36.39 to the actual basically the main roof. However, your ordinance does not allow for a bulkhead for an elevator, and it doesn't allow for a bulkhead for a stair tower. And again, I wasn't involved in some of the previous applications, but I believe the fire department, based on those previous applications, wanted full access to the roof through a stair tower and not just a hatch. And because of that appurtenance would need a variance, because the stair tower would come up roughly 9 feet, but just in that small section, which obviously Mr. Vagona can testify exactly how big it is, but roughly 10, I would say 10 by 20, where the stair tower would be. So we would need relief for that, and we would need relief for the actual bulkhead for the elevator, because that'll be up around 4.5 feet off the roof deck. But the majority of the roof is slightly above what exists today, 36. So we would really need a C variance for that. However, you would need a D variance because it's more than 10% that's allowed in the zone. So 35 feet, 3.5 feet. And again, Charles will certainly discuss it. Ray Vagona, the architect, will tell you exactly where it is, why it's necessary under the code as far as egress. And again, it's for a safety reason that we're proposing this. We don't have to do it, I don't believe. But based on previous applications before this board, the fire department requested that they could have full access, to the actual roof. The only other variances that we would require, there would be FAR, which they'll talk about that, or the gross floor area, and then the coverage requirements as far as the building coverage and the maximum lot coverage, which certainly they'll talk about in the future. We're proposing, obviously, landscaping, lighting, drainage. We're going to meet all the requirements for the drainage as far as capturing the water, holding the water, releasing it slowly. And basically, that's it. We'll create a streetscape, and I think it'll be a tremendous addition to the downtown. And I think it's actually in the spirit and the character of the ordinance, how it was set up. And again, the only thing that we're actually, the biggest thing is that the apartments, some of them in the back, will be at the grade level and not on the second floor. But we feel it'll be in the back of the building, not in the front of the building, and you still have the retail portion that the ordinance certainly wants.
So, Mr. Costa, in looking at the exhibit that's up on the screen, there's what appears to be a peach color and then a gray color.
Correct.
Is it fair to say that the peach is the footprint of the building, that the gray is the surface at grade level parking?
That's correct.
Now, Mr. Costa, you just testified with respect to the measurement and calculation of the height. Commercial and residential height is measured slightly different under the definition. Is that what you were referring to?
Correct.
And I believe it was on the third sheet of your exhibit, there looked to be about 1,500 points of measurement to get the height. Is that what all that red is? What are all those?
That's correct. That's actually, that's the way you calculate it per the definition in the ordinance. So you take the grade level, and again, you can't, the ordinance only allows 1.5 feet to change the grade, so you can't artificially inflate it in order to make the building higher. So your ordinance actually protects you from that, where you can only fill a certain portion to get credit for it. Once you go over that number, you can no longer take credit in order to make the building meet the criteria. So based on those calculations, based on what we did, those are the numbers that we would need relief. We worked closely with the architect to make sure that those numbers, his plan, our plan, is exactly the same, so there's no sleight of hand here. I believe your engineer reviewed it, and I think he concurs with our findings.
Now, Mr. Costa, you mentioned that with respect to the measurement of height and what the height relief is for, that it's your opinion that you take the highest part of the roof, which includes the appurtenance up on the roof, the stair tower, and the bulkhead for the
Well,
elevator?
We actually broke it down 3 ways. So we broke it down to the main roof, then we broke it down to the bulkhead for the elevator, and then we broke it down for the actual stair tower itself.
And obviously, the reason why we get into the D6 height variance is because at the highest point, which I believe is the stair tower,
Correct.
that puts you at 9.5 feet above what is permitted in the underlying zone.
Correct.
Mr. Costa, you had mentioned the Neglia review letters. Did you have the opportunity to review those letters?
I have.
And, Mr. Costa, I believe there was a March 18th, an August, and then a September 9th review letter.
Excuse me. Just a second, I'll tell you.
I have one dated October 15th.
Those were, I think the other ones were completeness.
I think the latest is September 9th of 2024.
Okay.
October 15th. October 15th should be the latest one. And that's the actual engineering review letter. Just for the record, the other ones were for completeness
Completeness, right.
purposes.
Which one are you going to talk about?
I don't know if I have that in here. but I can't. I apologize. I have the May, I have the revision number 1, and I have revision number 2. I don't have that review letter. I don't know if you, Mr. Lampe, I don't know if you have it.
It's like 12 pages long. I don't think you're going to have time to review it now.
So obviously, Mr. Costa, we're going to have to get the October 15th review letter to you in order to
You're not finishing with it.
review it.
No. Again, if I could get a copy, like I said, what we physically had is the March 18th, the August 6th, and the September 9th, which is revision number 2.
So, Mr. Costa, while we don't have the October 15th for you to discuss, in the September 9th, and again, I understand there may be additional comments in the October review letter, was there anything in the September review letter that you wanted to discuss specifically?
No, I take no exception. Actually, I reviewed it a few times today. We take no exception with any of the comments in the September letter.
Mr. Costa, you've prepared drainage calculations, you've submitted those drainage calculations.
We have.
Perhaps there's some comments in the October letter regarding those, but you would be more than willing to work with the team at Neglia to address any concerns raised with respect to drainage?
Absolutely.
Mr. Costa, did you have the opportunity to consider the removal of waste from the site and anything of that nature?
We have. We actually showed the turning templates to get the waste in and out. There's a trash room located on the, as you pull into the left side, so where the handicap ADA parking spaces are. We show the truck that can enter there and exit there, so it'll be all on-site, not off-site, with the garbage pickup. Certainly, Mr. Vigona can discuss the actual pickup inside the building. And as far as garbage, whether it's going to be compacted, you're going to have to recycle all of the above, and it's going to have to be taken care of, obviously, with the building, with 44 residents in the building. So it's of adequate size. We don't see any issues with garbage.
Can you discuss the hookups to the site from an engineering standpoint?
Obviously, water, gas, electric, sanitary sewer, and again, the storm drainage will tie directly into the municipal system. If you followed it, I'm sure it trips right into the Hackensack River, south of the reservoir, so it doesn't have any impact on a C1 category or anything like that.
Chairman, the remainder of Mr. Costa's testimony is going to be technical in nature, and obviously we're going to need the October comment letter from Neglia and Mr. Costa to review it in order to properly respond to any of the open items that would be contained in that letter. So I would ask
If
that.
there's any landscaping in that letter, if there's anything with lighting, we can certainly modify it. With today, with the LEDs, you can certainly go back, you can dim the lights, you can add the lights. You can do a lot more than you could years ago with the other lighting that was available. If you want additional landscaping, if you want streetscape designs, my client is willing to do all the above.
Why don't we hold off on that until you've had the opportunity to review it, and we won't speculate what the letter says.
Absolutely, Chairman.
Do you have anything further?
So, Mr. Chairman, obviously I'm going to need Mr. Costa to come back.
Obviously.
And he's going to provide the remainder of that testimony. So I have no other questions for Mr. Costa at this point in time.
Do you have any questions?
Do you want me to wait till he comes back, or how do you want to handle that? Because some of the stuff, some of the questions I have are related, obviously, to what's in our letter.
Okay.
It may be more beneficial.
Yeah, let's wait until he's had the opportunity to review it and testify on that. Do you have anything on any testimony we've heard so far?
Sure. So I guess as far as the parking, I think in your testimony, when you were comparing the numbers, you had indicated that the number that you have satisfies the residential. Is the intent for the parking to be for residential only?
It's a good question. And you know what? My lift is so much easier tonight because there's 3 more people that have to go behind me. So Bill Page is going to come up at some point and discuss the parking and how that parking is going to work, because obviously in that area in Oradell is a tremendous amount of parking that surrounds this building.
So, Mr. Chairman, what Mr. Costa is saying is he's not the right witness to actually provide that testimony. Mr. Page will be providing that testimony. I think what Mr. Costa was attempting to articulate was that the residential, in his mind, is parked and the commercial is not parked.
Correct.
Okay.
Now, whether you share that in reality, I'm sure he's going to talk about it. And then if you look at buildings today,
Yeah, let's have the traffic expert talk about
you got it.
parking.
The question will be answered at some point. Thank you.
Yeah.
As far as pedestrian access, can you talk a little bit about that? And the lay of the land and
Sure.
what the intent is there?
So pedestrian access, obviously, for the retail, you'll see there's concrete in the front of the building, and there's a sidewalk that runs along the entire front of the building at grade. So that would be access to the residential portion. To the commercial portion. As you turn the corner on Veldran, that's where the actual pedestrian will be into the lobby area there. And what I was trying to explain earlier, because you have half a level going down for the lower parking that's actually buried below the Kinderkamak grade, there's a half level or a break to get yourself back up to that lobby level. So lobby off of Veldran, you're at grade. Parking, the lower parking, you'll be half a story below grade. And then that'll be the split inside the building to either take the elevator to the lobby area, if you want to get there, or take the stair to get there.
Now, as far as the commercial access along Kinderkamak, I guess wherever the doors would be where the sidewalk would extend to, because I think there were some additional doors shown on the south side of the building, to the south on Kinderkamak.
Excuse me.
Where that large bump out is. I think there's some doors over there. So your sidewalk would extend that far?
I don't think those are operable. Mr. Costa, you're showing...
Yeah, I believe that's the mechanical room. It's not the retail. So where the sidewalks stop, it services the retail portion of the building. The corner piece below grade is the mechanical.
Yeah, but I think on the commercial,
No, above it, there's definitely.
I think there's doors there.
I think it should be glass floor.
Ground floor,
That's all. You might, I think you're correct.
Okay.
So, Mr. Costa, can we just do it this way?
That's
You've
showing
got
on
a
the...
4-foot wide concrete sidewalk entirely around the site along both streets?
Yes.
Off that concrete sidewalk along Kinderkamak, you've got a concrete walk area that's
Yes.
11 feet,
Yes.
and then between that concrete walk and the building, looks like you've got another concrete walkway, 5 feet?
Yes.
That's scaling right?
Yes.
So on this plan, it looks like that's abutting the parking spaces, but your testimony is those parking spaces are a whole grade or story below?
Correct.
What we're seeing?
Correct.
So from the 4-foot sidewalk along Kinderkamak, halfway or in the middle of the property, it looks like there's going to be some kind of plaza or piazza-like area. Is that accurate?
Well, yes, but again, that will bring you into the retail portion, and then there'll be a walkway along the front.
Okay.
What we need to make sure is whether or not there's a door just to the south of where that concrete ends, that we have to get to that door to service
And you would
possibly the last door.
And you would expand that
You would have to expand that, which would then
walk?
slightly change the coverage. That we would have to then obviously put that into the equation. Excuse me.
So in the event that there is a door to the south of where the concrete walk ends, you would expand that to reach that door?
Yes.
Okay. As far as access from Kinderkamak, do the residential properties have access to the street frontage?
They do not to Kinderkamak. Only the retail.
Okay.
Commercial.
Now, as far as I think you had talked about the sewer service, given the number of units, would a treatment works approval be required?
Yes.
Okay, as well as safe drinking water?
Yes.
Okay. As far as the drainage, I think you had testified that you would be tying into the existing system along Veldran.
Yes, we would.
Has any inspections been made related to the condition?
No.
Would that be something your applicant would be amendable to checking the condition before tying in? Should
I
the
got a
board look
nod,
favorable?
yes.
Okay. Trying to think what else without him going through the letter. We won't go through the stormwater because you should read that first. We did have a couple comments
Some
related to
people
that.
think I'm pretty good at stormwater. Just saying. But we'll read it.
Well, I'll leave it for you.
For Oradell, Mr. Costa.
Let's see here. As far as the proposed lighting, I think you briefly talked about the proposed lighting.
Yes.
Can you walk us through what's being proposed and if there's any lighting proposed along the street frontages as well?
Lighting plan?
Yeah, it's on
Sheet.
keep going.
I think it's 9.
We're getting next one.
That looks like lighting.
Okay. So you got 3 different fixtures that we're proposing. There's going to be obviously lighting at the surface level, excuse me. And then for the underground portion, obviously it's going to be in the ceiling mounted in the parking garage that's below grade. So you'll have 3 different ones, all LED. There's computer generation as far as the foot candles and the spillage that it's going to produce. If it does not meet the code, which I was under the impression it did, but certainly I'll go through your letter, and then we can certainly adjust it accordingly. As far as the actual street frontage, certainly we'll work with you if we're going to set up the streetscape similar to what the Kinderkamak Road streetscape, if that's what you want on the entire site. But again, whatever the board desires, we will do.
Okay.
If you want to use the brick again, I'm not sure. Excuse me, if you want to keep it concrete with some brick, however you want us to do it, if you want us to match that Kinderkamak look, not an issue. and set up the same lighting. I don't know if you guys want to use that similar lighting that you have there now, or you would want to use a different light for the street lighting. But certainly, we're willing to do any of the above.
Okay, fair enough. Now, as far as the parking, so the code does talk about every 10 parking spaces to be broken up with an island per the code. Looking at your plan, obviously, that's not adhered to. Can you talk about that?
We would again, we'd need relief on that. But again, parking, obviously, we think it's paramount as far as the building itself, how we laid it out. We do have landscaping around the entire perimeter of the site, and just that small portion that's exposed would have that requirement. But again, we'd have to obviously lose some parking spaces in order to do so.
All right. I'll leave some of the other more technical stuff till you had an opportunity to look at our letter, because it's definitely different than the other letter, because that was just for completeness purposes.
No problem.
As far as the site itself, are you aware of any easements or title restrictions? That may be more so the attorney related to the property. Okay, just want that on the record. I know you had talked about the fire department. Have you guys received any correspondence back from them?
I haven't, but again, based on some of the earlier letters that Mr. Vagona was involved in other applications here, that was a request from the fire department, and the thought process would be that they would want the same thing on this particular building.
Mr. Chairman, I have not received any letter from the fire department. I don't believe I received a letter from the police department either.
My office has not.
Okay.
We can reach out to them again.
Okay, please.
I also believe that the fire department may have been at the building for, I guess, inspection or to look at the building.
They did some practices there, fire department. They were allowed, I think. Yeah. Drills.
Okay. Last item I have, and this was in our completeness stuff, as it relates to any environmental impacts. Can you just briefly touch on that as far as the site and indicate if there's anything of
There's no
concern?
Yeah, I know you requested if there was wetlands, anything. There's no wetlands on the site. We'll give you documentation from an expert, but certainly there's no wetlands. The site is basically paved today with building. So what you're doing, again, and this is going to come up more and more because if anybody's reading the papers lately, a lot of these branches are closing, whether it's Bank of America, whether it's Wells Fargo, whether it's any of these branches. So this is coming down the road. And the question is, what do you do with these buildings that become vacant? Now you have a vacant building in the middle of your downtown, which is not desirable. So there's no impact, in my opinion, on there's going to be no impact on your stormwater. There's going to be no impact, quite frankly, on your traffic setup. If anything, and again, I don't want to take all the thunder away from this gentleman, but it's situated within very close proximity to the train. Highly, highly desirable. The state came out many years ago with the Transit Village with this in mind, that you put these things here and you put residential within the walking distance within a quarter mile of it, so you get use out of it. So you're actually not even using parking, commuter parking, because you're living there and you're using the train service. You got bus service that runs into New York. If anybody's used the train, it runs obviously into New York through Secaucus. So this location, highly, highly desirable. It meets your ordinance as far as it's permitted with conditions. And the reason we're in front of this board, based on those conditions, we need some relief, but I don't think it knocks out the spirit of what the ordinance says. And I'm sure this gentleman is going to tell you why he thinks that. And in my personal opinion, professional opinion, I feel the same way. So to go back to your answer, I don't see any negative impacts on environmentally.
Okay, thank you.
And we're south of the Oradell Reservoir. United Water ran that. They have their stuff there. They should be able to provide water to the site. There should be enough. There should be enough. I know of a couple mains that come through here. There should be enough water.
All right, fair enough. As far as ADA, I think you talked about that. You have the 3 ADA parking spaces when you come in. Everything's been designed to meet the ADA requirements?
Yes.
As far as slopes, grades? Okay.
Slopes, all 2%, no more than 2% any direction. Yes.
Okay, and same with all the new proposed sidewalk as well as around the perimeter of the property?
Yes.
That's it.
I just reserve my right to questions later.
Of course. Well, his testimony hasn't really been completed, so.
Yes.
Yeah. Caroline?
Thank you, Mr. Chairman. We're also in the process, as you and I discussed, of completing our report. But I do have a few questions based on your testimony and the plans as I've reviewed thus far. So first of all, actually, going back to what the engineer indicated about there being the surface lot not having, the spaces not being broken up, and I believe you said something like, something to the effect of we're trying to maximize our parking, we'd lose parking spaces doing that. Right, so you're deficient in parking, and then you're not meeting the parking standard requirement for certain improvements in the parking lot because you don't want to move more parking spaces. Do you think that any of this is an indication that there's a lot going on the property, that it can't be parked properly and maybe is just too many units or too much space for the site?
It's a good question.
It is a good question.
And there's 3 more witnesses behind me and who are going to say no. Basically, sad to say, granted, variances and economics cannot be together, but that's really not reality. So the reality is this. You take a site of a vacant bank in the middle of a downtown, and you need to then redevelop that. And the only way you're going to redevelop something, because it's a not-for-profit, it's a for-profit, that you need to look at it, and you need to look at it closely to say, how do you balance what we're asking for, how do you make it successful, and how do you get to a finish line? And I think you're going to hear 3 other witnesses say, this is what we came up with, the team. We're in front of the board. I understand what you're saying. Of course. Could you make it smaller? 1,000%. Could you meet everything that says in the ordinance? 1,000%. But the question becomes, is it ever going to get built? I don't know. And I think you got to weigh it, and you got to weigh the scale, what we're asking for to what we're actually doing, and whether the rest of that downtown with all of that other surface parking can handle this. And is that a better thing to have 44 residents there that can literally walk a couple of feet to a train than to say, let's limit that, and let's put that somewhere else in the town and not have the same convenience. And I think you got to look at all the above. And I think it's a very attractive building, and when you start weighing everything, then that'll come back to whether or not it's too big, not big enough, whether you can take a couple spaces out and put in some landscaping there.
Right.
We can do some environmental pavers, we can do it that way, and soften up the surface parking lot, add some brick pavers around the building, soften it up, add a little more landscaping, soften it up. All of these can be done.
I appreciate that, thank you. But my question, to clarify, wasn't about whether or not there was sufficient parking. My question had more to do with, is the parking, the lack of parking, and the inability to meet some of their standards for parking lots an indication that there's just a little too much going on in this property? That's what I was saying, because quite often when you, as you know, when you deal with site development, you have to, parking is sort of how you start. You have to be able to park your units or park your retail or park whatever the use is.
No question.
But I'm seeing here that you're not parking it, because you're, even with the EV credit, you're still requesting a variance.
We are.
And you can't meet the standards for the parking lot. So that was my question. It wasn't, so I recognize where the train station is and where the other parking lots are in downtown Oradell. My question really had more to do with if this was an indication of what's going on or what you're proposing. But I'm sure you have other witnesses who are going to be talking about that as well.
And they need to obviously...
Mr. Costa, that's a yes or no
variances.
question, and is it a yes or a no to her specific question, in your opinion? It would be no, it's not an indication, I would imagine.
It's not an indication of whether it's too big or small. The indication is whether or not this building will work. That's it. Whether or not this building is going to cause any negativity to this community if this board approves it. Because the last thing my client wants to do, or myself in front of this board, or any of these board members, is to approve something that is a failure down the road. Certainly, that's not what we want to do. And you'll hear testimony behind me to say, this is how many parking spaces there are, this is what this building will produce, this is what we think is going to happen, and whether or not that meets the standard, whether or not this board can say yes or no, or whether it has to get trimmed. That will come, obviously, in the future. But I think there's enough, and you're going to see testimony from Bill Page, there's enough parking, surface parking, around us that this is not going to be the straw that broke the camel's back, in our opinion.
Okay, thank you. So there is a use variance needed because you have residential uses on the ground floor, correct? And I think you testified they were at the back of the building. So what is the square footage of the building, and what is the square footage of the ground floor? Let me rephrase that. What's the square footage of the building envelope, and then what is the square footage of that is residential versus commercial? Is that more of an architectural question?
I don't want to give the wrong number.
Okay.
The commercial is 5,550 square feet,
Yeah,
I
you
believe.
said.
I think that's the right number. I'm not sure because again, the ground floor is going to be, obviously, the additional 6 units. It's going to be some mechanical, the lobby, rather.
Right.
The mechanical is going to be below, so I don't think that would actually come into play. And then, obviously, there's a lower little lobby area to get in the stairs. But let me give you I'd rather have the exact number so there's no, to make sure it's absolutely clear for the record.
Okay. I'll wait for the next witness.
Okay,
Thank you. And my question has to do with respect to the variance, of course. That's why I want to know the square footage and how much of the ground floor is residential versus commercial. Your plans, and this is definitely a question for you because it's your plans. Your plans indicate both the B1 and the B1 bulk table and the CBD overlay bulk table.
Correct.
So I understand that you're in the B1 zone, for which there is a CBD overlay. So which are we just using, though, to confirm the CBD regulations? We're not cherry picking, right? One from one and one from the other. Okay, we're just using CBD?
Correct, but we're showing the two.
So, Mr. Regan, that was asked for to be placed on the plan that way during the reviewing process. And there were questions as to what variances.
Who made that request?
Is it in the completeness?
I believe it was in the completeness through Neglia Engineering.
I just wanted to clarify.
I just want to make sure I just want to understand it myself. So
Well, but
that's fine.
I want to be clear that there is a question of what variances are actually needed. We're going to have planning testimony. I understand your position as the board planner that this is a D1 and a D6 without question, as I understood it being relayed through the Neglia letter. But we're going to have planning testimony that's going to break down the ordinance. Mr. Costa was identifying the variances as instructed and put on the table. But we are going to have detailed planning testimony to go through all of that with the appropriate proofs, obviously, positive and negative criteria from Mr. Height when we get to that. So I don't want Mr. Costa to answer questions that he shouldn't be answering because he tends to answer any question asked of him.
I'm just looking at the Neglia letter of September 9th, revision 2. It is on page 9 of 12, paragraph 4.2 at the bottom about the CBD overlay being added.
Okay. I just wanted to, for clarification purposes.
It was asked for, there it is. There was a question whether or not this variance was required or not. Based on the team, based on that, a lot of back and forth. And again, at some point, someone's going to have to make a decision to say, yes, this is what's required and this is not what's required. And I guess that'll come as you look at it very closely, and then Charles will get involved and everybody can figure it out.
Right, and as was...
And Mr. Regan can figure it out, and Mr. Olampi.
And we...
In front of the zoning board for a reason, so.
Yeah, that's right. And we did work with Mr. Atkinson's office to identify the variances. through his completeness review, if I'm recalling correctly. That was this application,
Yes.
correct?
Correct.
That's correct. Okay. That was, you're going to be back, so, and I'll be finalizing our review, so.
Once I get both letters, I will be, we will blow them up, we will put them up there, and we will have them answered before we even get here. And if we have to change something prior to that, coming back here, Mr. Chairman, members of the board will do so accordingly. And again, whatever your wish is our command. So whatever you guys want, through your professionals, through the board, we want to make this project something that this town can be very proud of. So we're not here to fail.
That's all I have, Mr. Chairman.
Steve, do you have any questions? Bob?
My question is related to Mr. Atkins' letter of October 15th,
So we'll hold that up. Okay. Any member of the board have any questions on this? Okay. I'm not going to open it to the public because you're not completed with your testimony. We're just doing that. It's 10:30 and you were scheduled to finish at 10:40, so I don't know if you want to take the next 10 minutes or...
Chairman, I think this is the ideal place to break. Mr. Costa's going to get a hold of the October 15th letter and be prepared to respond to it. I've been sitting here all evening. I understand November 18th is...
November 18th, 7:30, without need for further notice. Thank you.
Chairman, thank you. Members of the board,
Thank you.
thank you. Certainly the public.
Okay.
Thank you, everybody.
All right, thank you. Moving on with the agenda, old business. Does any member of the board have any old business?
Just leave it there.
All right. I have, okay, if we could, I have one thing on old business. It was mentioned a couple of months ago that there was, I'm thinking of whether we would go for a combined board or keep the zoning board in place. I don't know where we are at this point. I just want to offer an observation. If the board is abolished at the end of this year, that means that any case that's ongoing at this point would have to be voted on at the November meeting. If it's not voted on at the November meeting, we would not be able to adopt a resolution because, let's say, we vote on it in December. There would be no board to approve a resolution in January. So we need to consider that. If the board is abolished later on, let's say February, March of next year, gives you some time, but once again, you have to allow 1 month after a vote in order to allow for a resolution to be adopted. I will say simply, my preference and my belief, what's best for the borough, is to keep the Zoning Board of Adjustment in place. But that's a decision for the mayor and council. I don't get a vote in that one. So that's it. My point on old business. Do we have any other old business to discuss? New business. Does anyone have any new business? No. Then I'll open the meeting to the public. Not seeing a show of hands, I will close the meeting to the public. It is 10:33. Do I have a motion to adjourn?
Awesome.
Do I have a second?
Sure.
All in favor? Aye. Any opposed? No. Meeting adjourned. It is 10:33 p.m.
Is very clear. As per this resolution, the Lebanese army should be deployed in the south, but it's also should be equipped in order for it to be able to defend Lebanon from potential